It is my honest and sincere belief, one which I will back up with evidence in this video, that Donald Trump tried and failed to steal the 2020 presidential election. I'm going to lay out everything in as straightforward and comprehensive a manner possible. And additionally, I'm also going to respond to a list of common criticisms that Trump supporters regularly bring against this evidence. If you're wondering why this video has to be so long, well, that's why. It's my intention that this project be a fully comprehensive view of the facts, backed up by all available evidence, presented as straightforwardly as possible. We are deep diving almost everything related to Trump's attempt to steal 2020. I'm also going to present all of this with as little of my own moral judgment as possible, at least until the end where I give you my thoughts. So, let's get started. On January 6th, 2020, at 7 a.m., the Save America rally began on the ellipse south of the White House. This event was organized by the political advocacy group Women for Trump. The official itinerary for the rally showed the gates opening at 7, and by around 8 a.m. there were various opening ceremony-style events, like the Pledge of Allegiance to kick things off. Beginning at 8:10 a.m., various videos and live speakers presented to the crowd the view that Donald Trump had actually won the 2020 election, and the Democrats in the deep state and Joe Biden had stolen it from him.
Republican senators and congressmen will either vote to turn America into a godless, amoral, dictatorial, oppressed, and socialist nation on the decline, or they will join us and they will fight and vote against voter fraud and election theft and vote for keeping America great.
We want to restore the vote in our country because we all know, they all know, this election was severely compromised, and we're going to make sure that that never happens again.
We're not going to let them steal an election, because this isn't about stealing an election from Donald J. Trump. This is about stealing an election from we the people, and we are here to save the republic.
I've got a question for you. Is there any person here that actually thinks that Joe Biden won this election? I don't either, guys. I don't either.
And it should be a message to all the Republicans who have not been willing to actually fight. The people who did nothing to stop this steal.
The Democrats, with all the fraud they have done in this election, the Republicans hiding and not fighting, they are trying to silence your voice.
None of these claims were true, but it's unclear if most of the speakers knew they were repeating false claims. However, both Donald Trump and Rudy Giuliani did know, which is something we'll cover a little bit later. The various speakers and videos were scheduled to continue until 11 a.m., when Trump himself was to give a speech. And this itinerary is mostly accurate to how the day played out. It ran later than planned, some people spoke for longer than their allotted time, and Trump didn't show up until noon. But if you want, you can go on C-SPAN and watch the entire 5-hour event for yourself, entirely uncut and uncensored. And if you did so, you would notice something a bit strange. During Rudy Giuliani's segment, scheduled at around 9:30 a.m., there's this weird Inspector Gadget-looking dude hanging out on the stage beside him. And after Giuliani's done speaking, this guy gives his own remarks, the only event of the day that is entirely unscheduled. This man is Professor John Eastman, a lawyer employed by Donald Trump. Born in Nebraska, he attended the University of Dallas, and later the University of Chicago, in order to get his doctorate of law. As an adult, he lives in California, and he's practiced law there for decades, though he was eventually disbarred due to his actions surrounding January 6th. John Eastman is most well known for the legal assistance he offered to Trump in his attempt to overturn Joe Biden's 2020 electoral win, a plan he transcribed in 2 documents, which are now colloquially known as the Eastman Memos. During his short speech, Eastman reinforced the previous false claims that the vote was rigged against Trump.
We know there was fraud, traditional fraud that occurred. We know that dead people voted. But we now know, because we caught it live last time in real time, how the machines contributed to that fraud.
In fact, that's pretty much the only thing he said. He didn't talk about his actual plans, the stuff he laid out in the memos that bore his name. But those memos are also public, and we can read them for ourselves. Also, as a quick aside, the next segment after Eastman, for some reason, featured a remix of Linkin Park's In the End.
What truly matters is not which party controls our government, but whether our government is controlled by the people. too long, a small group in our nation's capital has reaped the rewards of government.
One thing, I don't know why, it doesn't even matter how hard you try.
I kind of feel like I'm back in high school. I don't know, maybe they're tapping into that anime FMV energy. Really get the crowd fired up for a fight, you know? Okay, let's go over the contents of the Eastman Memo. The following is Eastman's view of the relevant electoral law, and it's pretty long and technical even after I've cut it down to the bare minimum. So, if you want to skip to what all this means, jump ahead to 9 minutes, 12 seconds.
7 states have transmitted dual slates of electors to the President of the Senate. The 12th Amendment merely provides that the President of the Senate, that's the VP, Mike Pence in this case, shall, in the President of the Senate and House of Representatives, open all the certificates and the votes shall then be counted. There is very solid legal authority and historical precedent for the view that the President of the Senate does the counting, including the resolution of disputed electoral votes, as Adams and Jefferson did while Vice President, regarding their own election as President, and all the members of Congress can do is watch. The Electoral Count Act, which is likely unconstitutional, provides, if more than one return or paper purporting to be a return from a state shall have been received by the President of the Senate, those votes, and those only, shall be counted which shall have been regularly given by the appointed electors. In such case of more than one return, if there shall have been no such determination of the question in the state, then those votes, and those only, shall be counted which the two houses shall concurrently decide were cast by lawful electors appointed in accordance with the laws of the state, unless the two houses, acting separately, shall concurrently decide such votes not to be the lawful votes of the legally appointed electors of such state. This is the piece that we believe is unconstitutional. It allows the two houses, acting separately, to decide the question, whereas the 12th Amendment provides only for a joint session. And if there is disagreement, under the Act, the slate certified by the executive of the state is to be counted, regardless of the evidence that exists regarding the election, and regardless of whether there was ever fair review of what happened in the election by judges and/or state legislatures. So here's the scenario we propose. 1. VP Pence, presiding over the joint session, begins to open and count the ballots, starting alphabetically with Alabama. 2. When he gets to Arizona, he announces that he has multiple slates of electors, and so is going to defer a decision on that until finishing the other states. This would be the first break with the procedure set out in the Electoral Count Act. 3. At the end, he announces that because of the ongoing disputes in the 7 states, there are no electors that can be deemed validly appointed in those states. That means the total number of electors appointed, the language of the 12th Amendment, is 454. A majority of the electors appointed would therefore be 228. There are at this point 232 votes for Trump, 222 votes for Biden. Pence then gavels President Trump as re-elected. 4. Howls, of course, from the Democrats, who now claim that 270 is required. So Pence says fine. Pursuant to the 12th Amendment, no candidate has achieved the necessary majority. That sends the matter to the House, where the votes shall be taken by states, the representation from each state having one vote. Republicans currently control 26 of the state delegations, the bare majority needed to win that vote. President Trump is re-elected there as well. 5. Assuming the Electoral Count Act process is followed and, upon getting the objections of the Arizona slates, the two houses break into their separate chambers, we should not allow the Electoral Count Act constraint on debate to control. So someone, Ted Cruz, Rand Paul, etc., should demand normal rules, which includes the filibuster. That creates a stalemate that would give the state legislatures more time to weigh in to formally support the alternate slate of electors, if they had not already done so. 6. The main thing here is that Pence should do this without asking for permission, either from a vote of the joint session or from the court. That the other side challenges actions in court. The fact is that the Constitution assigns this power to the Vice President as the ultimate arbiter. We should take all of our actions with that in mind.
Alright, here's what's going on. I'm sure most of you know, but just in case you don't. America's presidential elections are done via an Electoral College system. What this means is you don't actually vote for president. You vote for a guy whose job it is to travel to Washington, D.C. in time for January 6th and vote for president in your stead. These people are called electors. The Constitution explicitly states in Article 2, Section 1, Clause 2, that the state governments are the final arbiter of the process of deciding how to appoint electors. This is why state governments run presidential elections, despite the office of the president being federal level. This is also why a lot of states have winner-take-all systems for their electors, but not all of them. There is no one consistent standard, because it is left to the states. Maine and Nebraska assign their electors proportionally, per their own state law. After Election Day, the votes are counted, the electors are appointed by the state government as per the result of the vote, and in accordance with state law, generally sometime in December, and then the electors make their way to the Capitol. The system is set up like this because back in the day, getting to DC on horseback could take weeks, and something majorly disruptive could have happened in the interim. You see, up until recently, the electors actually had the authority to cast their vote for a candidate other than who their constituents had chosen back on Election Day. An example of this happening is in the 1872 presidential election, where Horace Greeley won 66 Electoral College votes, but he died in between Election Day and the day the Electoral College met. As a result, the 66 electors formally pledged to support Greeley were free to vote for whoever they liked. This is sometimes called an open college, where a substantial number of electors are free to vote by their own interests, due to a candidate dying or dropping out. However, the authority of the electors to disregard their constituents, on paper, applied not only to cases where a candidate died or dropped out, but in all cases. Theoretically, electors could simply vote for whoever they wanted, at any time, for any reason. This is called a faithless elector, and throughout history, they were pretty rare, and they never actually swung any election. However, their existence is what some Democrats in 2016 relied on as a last-ditch effort to try and prevent Donald Trump from taking office. A campaign which culminated in this incredibly cringe TV commercial, where Hollywood celebrities came out to beg electors to vote for Hillary instead, or at least not vote at all.
Republican members of the Electoral College, this message is for you. As you know, our founding fathers built the Electoral College to safeguard the American people from the dangers of a demagogue and to ensure that the presidency only goes to someone who is to an eminent degree endowed with the requisite qualifications.
An eminent degree. Someone who is highly qualified for the job.
The Electoral College was created specifically to prevent an unfit candidate from becoming president.
There are 538 members of the Electoral College. You
and just 36 other conscientious Republican electors can make a difference
by voting your conscience on December 19th.
And thereby shaping the future of our nation.
I'm not asking you to vote for Hillary Clinton.
I'm not asking you to vote for Hillary Clinton.
I'm not asking you to vote for Hillary Clinton.
As you know, the Constitution gives electors the right to vote for any eligible person.
Any eligible person, no matter which party they belong to.
But it should certainly be someone you consider especially competent.
Especially competent to serve as President of the United States of America.
By voting your conscience, you and other brave Republican electors can give the House of Representatives the option to select a qualified candidate for the presidency.
I stand with you.
I stand with you.
I stand with you.
I stand with you in support and solidarity with conservatives, independents, and liberals.
And all citizens of the United States.
The American people trust that your voice speaks for us all.
And that you will make yourself heard through the constitutional responsibility granted to you by Alexander Hamilton himself.
What is evident is that Donald Trump lacks more than the qualifications to be president.
He lacks the necessary stability.
And clearly the respect for the Constitution of our great nation.
You have the position,
the authority,
and the opportunity to go down in the books as an American hero
who changed the course of history.
And you have my respect.
You have my respect.
You have my respect.
For your patriotism.
And service to the American people. Unite for America.
This campaign never went anywhere. In fact, most Americans, regardless of political persuasion, found it insulting that a bunch of Hollywood celebs would come together from on high to try and convince the electors to disregard the will of the people. It felt a lot like elites telling the commoners they voted wrong, you know? And considering the shenaniganery surrounding the electors just 4 years later, from the Republican side this time, against the interests of these celebs, I'm not surprised that this video has been completely scrubbed off the internet and their involvement quietly buried. One of them mentioned Alexander Hamilton in there, and we should actually go over his contribution to this process briefly. Hamilton was one of the founding fathers. He contributed heavily to the Constitution, and he was also a big proponent of the Electoral College due to his distrust of direct democracy. He wrote about his logic in the Federalist Papers number 68. Hamilton believed, correctly I might add, that democracy could descend into the anarchy of mob rule if left unguided. His view of the Electoral College was that it should be an institution made up of men who were, quote, most capable of analyzing the qualities adapted to the station, acting under circumstances favorable to deliberation, into a judicious combination of all the reasons and inducements which were proper to govern their choice. In other words, Hamilton wanted the Electoral College to be a body of sober second thought, where the electors would generally adhere to the will of the people, but could override it if absolutely necessary. And so the people themselves, who were the electors, had to be individuals of achievement with wisdom and good social standing. What Hamilton hoped to safeguard against with this arrangement was the desire in foreign powers to gain an improper ascendant in our councils. In other words, Hamilton feared the election of a Manchurian candidate. This was the logic that some die-hard anti-Trump Democrats, with those Hollywood celebs in their corner, attempted to lean on back in 2016. That Donald Trump was unfit for office. He was a Russian plant, in fact. And so the electors had a responsibility to use their powers as Alexander Hamilton intended. A Change.org petition on the matter got nearly 5 million signatures, and the money raised as a result from the publicity of that campaign was used to purchase a bunch of advertisement space throughout December of 2016, where this flyer was printed in an attempt to pressure Republican electors to abandon Donald Trump. However, by this point, the electors had, in practice, if not strictly in law, become largely ceremonial. The 1952 Supreme Court case, Ray versus Blair, determined that the state government's right to appoint its electors how they saw fit, as per Article 2, Section 1, Clause 2 of the Constitution, overrode Hamilton's vision of the Electoral College as an independent power broker, as laid out in Federalist 68. This confirmed the state government's authority to outlaw faithless electors if they so chose, and some of them did. In the end, despite the Democrat campaign to try and utilize faithless electors in the 2016 election, Hillary Clinton actually saw more electors defect from her camp than Trump, her 5 to his 2. On top of that, an additional 3 tried to abandon Hillary, but they were from states who had outlawed the practice, so their efforts were invalidated. This wasn't enough to swing the election, but as a result of the highly publicized attempt to utilize faithless electors, as well as the fact that there were 10 of them, way more than normal for a modern election, many states began the process of outlawing the practice. As of today, 38 states have done so. Some of them void the change to vote, some of them void the change to vote and punish the elector with a fine, some of them actually keep the change to vote but still punish the elector, weirdly enough. In only 15 states is the practice still fully allowed. And for the 2016 faithless electors, these punishments largely went through. The 4 faithless electors from Washington state were each fined $1,000 for refusing to vote for Hillary, even though their vote was accepted on January 6, 2017. In Colorado, 3 electors filed suit after their vote, also moving away from Hillary, was invalidated by Colorado's Department of State. Both cases were consolidated and made their way to the Supreme Court, where it was ruled unanimously on July 6, 2020, that states can, in fact, legally require electors to vote for the candidate to whom they had pledged, and furthermore that imposing a fine for not doing so was not unlawful. However, Justice Sotomayor had to recuse herself from the case due to a personal relationship with one of the Colorado faithless electors. The 12th Amendment makes it clear that the final arbiter of this matter is the state government. Each state decides whether to allow faithless electors or not, or believe it or not, whether to have an election at all. In 1788, Connecticut, Delaware, Georgia, New Jersey, and South Carolina had the state legislatures vote on the appointment of electors, not the state's population. And New York didn't send electors at all that year, because the state legislature couldn't decide who to send in time. According to the history book, The People's President, states tried multiple systems over the years. Legislative appointment, executive appointment, but by 1832, every state government, except South Carolina, had settled on the popular vote. The final state to send electors in any other way was Colorado in 1876, only because the state had just been formed a few months prior, and there wasn't enough time or money to set up an election. Supreme Court Justice Joseph Story wrote in his 1833 book Commentaries on the Constitution, which is considered to be the greatest analysis of its kind, and is still routinely cited in court, that although he had high praise for the United States Constitution, he also saw some flaws in it, mainly around the Electoral College. He understood the dangers of mob rule, cronyism, and foreign interference that Alexander Hamilton foresaw 60 years earlier, but he remarked that in guarding against those dangers, a gap had opened up, and a different weakness appeared. In discussing the 12th Amendment's provision that the legislative branch decide Electoral College disputes by state delegation, Story wrote, "This mode of choice by the House of Representatives will give rise to the worst intrigues, and if ever the arts of corruption shall prevail in the choice of president, they will prevail by first throwing the choice into the House of Representatives, and then assailing the virtue and independence of members holding the state vote, by all those motives of honor and reward which can be so easily applied by a bold and ambitious candidate." In other words, a corrupt presidential candidate who's willing to take the necessary actions to illegitimately seize the presidency need only gather together a small cabal of equally corrupt House reps, and the Constitution offers no remedy. I want you to keep Judge Story's criticism in mind as this video progresses. Anyway, my point in saying all of this is that although every state has ultimately settled on the popular vote to determine its electors, it's the electors themselves who cast the ballot for president in an electoral college system, not the voter, even if that distinction has been made more symbolic in a lot of states post-2016. John Eastman's plan, as laid out in his memos, is to present to the counter of the Electoral College votes, the then current Vice President Mike Pence, two competing sets of electors for 7 of the states, colloquially known as Dueling Electors. Pence would then use the existence of the Dueling Electors to toss the votes from those states entirely, declaring a Trump victory. That was Eastman's first plan. If it failed, the fallback plan was to have Pence use his authority to kick the matter back down to the House of Representatives, which is the constitutional process for when no candidate receives a majority of electors, as laid out in the 12th Amendment. In a special session of the House, each state delegation would cast 1 vote apiece to decide who wins the election. This means that all of the House reps from each state get together and decide who gets their one collective vote. The 1 rep from Alaska decides the 1 Alaskan vote, and the 52 reps from California decide the 1 Californian vote. Because the Republicans held a majority of the state delegations in the House in 2020, 26 versus 24, they would presumably also vote that Trump won the election. Eastman also mentioned that if Pence didn't follow the plan and refused to set aside the dueling electors, senators friendly to Trump's cause would use their power to object to the counting of a state's electors, which would trigger a special debate on the issue. Though the Electoral Count Act lays out rules for this special debate, setting a maximum time limit of 2 hours, Eastman's plan was to ignore the Electoral Count Act, under the belief that it was unconstitutional, insist on normal Senate rules, which includes the indefinite filibuster, and then have Senate Republicans halt the entire process until, hopefully, the 7 states in question ratified Trump's half of the dueling electors. What happened in reality is, Pence refused to go along with the plan, rejecting the dueling electors entirely and counting only the legitimate ones. Senate Republicans did object to the counting of electors, as was their right.
Are there any objections to counting the certificate of vote of the state of Arizona that the teller has verified appears to be regular in form and authentic?
Mr. Vice President, I, Paul Gosar from Arizona.
For what purpose does the gentleman from Arizona rise?
I rise up for myself and 60 of my colleagues to object to the counting of the electoral ballots from Arizona.
Is the objection in writing and signed by a senator?
Yes, it is.
It is. The 2 houses will withdraw from joint session. Each house will deliberate separately on the pending objection and report its decision back to the joint session. The Senate will now retire to its chamber.
But the procedure laid out in the Electoral Count Act was followed properly. The special debates on the electors were not subject to filibuster, and after the allotted debate time ran out, the arguments presented by Senate Republicans were not convincing enough to toss out any of the electors.
We're debating a step that has never been taken in American history, whether Congress should overrule the voters and overturn a presidential election. I've served 36 years in the Senate. This will be the most important vote I've ever cast. The Constitution gives us here in Congress a limited role. We cannot simply declare ourselves a national board of elections on steroids. If this election were overturned by mere allegations from the losing side, our democracy would enter a death spiral. We'd never see the whole nation accept an election again.
Additionally, the Senate chamber was breached by rioters during this process.
And it will stand in recess until the call of the chair.
We'll pause.
Protesters are in the building.
Thank you.
There wasn't anything you said.
Protesters on the floor milling about, at least one of those protesters wearing a Trump flag as a cape. You can see another one appears to be unloading a suitcase or duffel bag of some sort, and the protesters appear to have total and unrestricted control of the Senate floor. I don't see any Capitol Police presence there at all on the U.S. Senate floor.
An event which put a serious damper on any further challenges after the Senate reconvened.
Is the objection in writing and signed by a member and a senator?
Mr. President, prior to the actions and events of today, we did, but following the events of today, it appears that some senators have withdrawn their objection.
In that case, the objection cannot be entertained.
Here's a quick recap of everything. The Vice President's duty on January 6th is laid out by the 12th Amendment of the Constitution and the Electoral Count Act of 1887. During the 2020 election, as per the 12th Amendment, Mike Pence's job was to open and count the Electoral College ballots in the presence of both the House and the Senate. And as per the Electoral Count Act, if one House member and one senator from a state objected to their state's Electoral College ballots in writing, the two bodies would retire to their chambers, and Pence was to preside over a debate of the validity of the electors in question in the Senate. A similar debate would take place in the House, with the Speaker presiding. In the matter of dueling electors, where two sets of electors both claim to be legitimate, the VP is to accept the electors explicitly authorized by the state's government. And if no authorization exists, the House and Senate would debate and decide which electors to accept, specifically making their determination in accordance with that state's laws. John Eastman's plan was to interpret the 12th Amendment as giving the Vice President the unilateral power to reject electors as he individually saw fit, disregarding the Electoral Count Act as an unconstitutional infringement of the legislative branch of government onto the duties of the executive branch, paving the way for Mike Pence to toss out Biden electors and install Trump as president. Pence rejected this logic, and the process played out as it was meant to. Well, except for the rioting. That's the basic skeleton of the Eastman scheme, which will be filled out with more details as we go. But at this point, I want to answer the first commonly asked question about this whole thing. Where did this Eastman scheme come from? As far as I can tell, it originated with Kenneth Chesebro, a lawyer associated with the Trump campaign. He wrote 3 similar memos to Eastman's on November 18th, December 6th, and December 9th, laying out a less developed version of the plan, where alternate electors would be filed in Chesebro's home state of Wisconsin, with the hopes they could be used as a wedge by Pence during the meeting of the Electoral College. In his December 6th memo, Chesebro wrote that alternate sets of electors needed to meet and vote on December 14th, alongside the legitimate ones, in order to craft a scenario in which Biden can be prevented from getting 270 electors, even if Trump's court decisions don't go through. He also said the Supreme Court would probably rule against this, but that's okay, because it would guarantee public focus on the electoral abuses of the Democrats. And finally, he said that this plan would probably leak to the public eventually, so they should have media messaging ready to go, describing the creation of alternate electors as a normal safeguarding process to the public. Also, despite Chesebro claiming he doesn't support this plan in his memo, it turns out he also ran the anonymous Twitter account Badger Pundit, which enthusiastically promoted the plan back at the time. Additionally, Jake Wilenchik, a Phoenix-based lawyer who helped organize Arizona's dueling electors on the ground, recounted a phone call he had with Chesebro in an email, where he said, "I just talked to him. His idea is basically that all of us, Georgia, Wisconsin, Arizona, Pennsylvania, etc., have our electors send in their votes, even though the votes aren't legal under federal law because they're not signed by the governor, so that members of Congress can fight about whether they should be counted on January 6th. They could potentially argue that they're not bound by federal law because they're Congress and make the law. It's kind of wild and creative. I'm happy to discuss it." My comment to him was that I guess there's no harm in it, legally at least. We would just be sending in fake electoral votes to Pence, so that someone in Congress can make an objection when they start counting, and start arguing that the fake votes should be counted. In a later email in the chain, Wilenchik said alternative votes is probably a better term than fake votes, with a smiley emoji. When Wilenchik admits that the votes aren't legal, it is odd he also says there's no harm in it legally, when in many states this would be considered filing a false instrument, which is a felony charge. Keep that in mind for later. Ivan Raiklin, a lawyer, Army reservist, and associate of Michael Flynn, tweeted out Chesebro's plans on December 16th, 2020, calling it the Pence card, which Trump retweeted. This formulation of the plan hinged on the Vice President's constitutional authority to request electoral vote certificates from any state that had not yet sent any to the National Archives by the 4th Wednesday in December. That day, the 23rd, came and went, and Pence did not invoke that authority, because all 50 states had, in fact, submitted their Electoral College papers to the archives. Eastman would go on to publish his 2 memos on December 23rd and January 3rd respectively, which is when the plan began to be noticed by more mainstream figures. Raiklin described his version of the plan, and the logic behind it, in an interview sometime in December of 2020.
On January 6th, he could say, you know what? Due to the precedent set by Speaker Pelosi at the last State of the Union by the President, she set a precedent to shred documents in the chambers. So I have to follow that precedent. And because the Constitution has been violated by these 6 states that, unconstitutionally submitted their slates of electors, I'm going to have to tear it on C-SPAN for everyone to meme about. And to be honest, and the crowd's going to go wild.
Yes.
It's going to be,
Yeah. Can the Senate push back to say that he doesn't have, does he have to present this information to the Senate?
That's the next question. Here's what happens. He has the sole plenary authority is my argument. And you know why? Because it changes the dynamic of this entire election by him doing this. he does this today. Again, statutorily, it has to be done today. And then if somebody disagrees with this assessment, what's the recourse? I would say there's two groups that have standing. So the states can say, you know what? The vice president violated the Constitution. He can't do that. Well, state your case. Now you're the plaintiff. And the vice president sits back and just kind of waits. No, I'm right. Now appeal your case after you go to the district court. Appeal it to the Court of Appeals in the respective court of appeals. And then after that, go ahead and appeal it to the Supreme Court. My assessment, let me ask you what your assessment is. What do you think the Supreme Court will do if it gets to them on this particular issue, based on what we've seen with the Texas case? It's rhetorical.
I think that they're going to throw it out.
They're not even going to take it.
Yeah, they're not even, just like they did with Texas. They didn't look at it.
Whose decision stands? The president of the Senate's decision, or the state that's in a disagreement?
But if they do make an argument, they have to prove their case.
The burden of proof then falls on the states or the Biden-Harris campaign. They say, oh, you can't do that. And you know what the rebuttal is? What the president of the Senate's response would be if I was advising? I would say, you know what? Neither the states nor the Biden-Harris campaign has standing until they have been harmed. And that harm only occurs when they lose the election on January 6th at 1 p.m. and a few hours later after the vote occurs. That's when they can file suit. And you think the Supreme Court's going to take it after that vote on January 6th when Trump and Pence win 232 to 227? I doubt it.
The logic that Raiklin is leaning on here is that regardless of any of the other facts of the matter, Pence should not abide by custom, precedent, or law. He should simply seize the moment and assert the authority to unilaterally discard electors, putting the onus on either the courts or Congress to take a positive action to try and stop him. Because Raiklin believed that once the action had already been taken, once the threshold had already been crossed, the other powers would be reticent to walk it back. In other words, the genie would be out of the bottle. As you'll see a bit later, this is the same logic that Eastman also leaned on. Raiklin is informally involved in Trump's affairs. He's mentioned on a July 2021 attendee sheet for an election remediation meeting along with Eastman. A militia that Flynn and Raiklin are associated with, the First Amendment Praetorians, or 1AP, had a man in Trump's inner circle, alongside Chesebro and Eastman. Additionally, Robert Lewis of 1AP mentions Raiklin as one of several legal counsels in their corner, though not directly by name.
It was my security team that drove Sidney Powell and General Flynn to the White House when they saw POTUS 2 weeks ago, and he wanted to appoint her as a special counsel. Then they left, and there was a certain White House chief of staff that came in after them and told President Trump not to trust her, not to believe her, that she has a terrible reputation. This same chief of staff, we've been trying to get messages and get people in to see him that have, we've been wargaming here nonstop. And we have, it really is amazing the amount of stuff that we have, constitutional scholars that have been here in our little suite, talking about the different things we can do, constitutionality of how they can do it, how much time he has. And we've been trying to get people in to tell him that.
However, Raiklin himself mentions in a December 7th interview that he was a part of the efforts to contact representatives to get them on board with the plan.
Is going to create that framework to then help the House and Senate decide, if necessary, who to vote for and determine which states have legitimate electors that were elected that didn't have any of this fraud. That's why Mo Brooks and 2 other congressmen already have pledged that, you know what? I've been talking to one of them, actually 2. They already committed to denying, or I should say, not denying, the operative word is objecting to the 6 states that are in contest. They're going to object allowing those states to count in the Electoral College vote.
And it's a draft of one of his memos that eventually made its way to Trump's desk, through either Eastman or Chesebro. So that is the origin of the Eastman scheme. Despite it bearing John Eastman's name, many other individuals were involved in its creation and propagation, not only Raiklin and Chesebro, many of whom we'll discuss later in the video. Personally, I think the reason it came to be known as the Eastman scheme in the eyes of the public, and not the Chesebro scheme or whoever else was involved, is because ultimately it was Eastman who was the new face at the Save America rally, who Trump and Giuliani both directly praised during their speeches. Another question I've seen some right-leaning people online ask is, did Trump actually know about all this? Was it all just Eastman and Chesebro and Raiklin pushing their own weird theories, while Trump had nothing to do with it? I mean, the answer to that's obviously no, because Eastman was employed by Trump. Eastman later recounted that Trump approached him. Eastman was at Trump's rally. Trump retweeted the Pence card idea that Eastman would eventually use, but there's way more evidence than what we've just seen so far. Here's a basic timeline of Trump's knowledge of the Eastman scheme and his participation in it. Cassidy Hutchinson, the aide to Mark Meadows, Trump's chief of staff, testified to Congress under oath that plans for the alternate electors required for the Eastman scheme began to be discussed around Thanksgiving. That's November 26, 2020.
Who do you remember being involved in those early discussions around the Thanksgiving time regarding having alternate electors meet?
Mr. Giuliani, several of Mr. Giuliani's associates, Mr. Meadows, members of Congress, although it's difficult to distinguish if the members I'm thinking of were involved during Thanksgiving or if they were involved as we progress through December.
Ronna McDaniel, the chair of the Republican National Convention, also testified to Congress under oath that at some point in December, she can't recall when, Trump put her on a call with Eastman, where they stressed the importance of gathering alternate electors for the upcoming plan.
What did the president say when he called you?
Essentially, he turned the call over to Mr. Eastman, who then proceeded to talk about the importance of the RNC helping the campaign gather these contingent electors in case any of the legal challenges that were ongoing changed the result of any of the states. I think more just helping them reach out and assemble them. But my understanding is the campaign did take the lead, and we just were helping them in that role.
Mark Meadows, Trump's chief of staff, sent Chesebro's memos to Jason Miller, Trump's senior campaign advisor, on December 6th, saying in an email that we just need to have someone coordinating the electors for the states. Josh Findlay, a lawyer working for Trump's campaign at the time, testified to Congress under oath that Trump decided to pursue the Pence card plan around December 7th or 8th, and he, along with others, were asked by the campaign to look into its legal viability. During that infamous January 2nd group call to Georgia Secretary of State Brad Raffensperger, Eastman was also on that call as well.
Look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state, and flipping the state is a great testament to our country, because, you know, and there's just, it's a testament that they can admit to a mistake, or whatever you want to call it, if it was a mistake. I don't know. A lot of people think it wasn't a mistake. It was much more criminal than that.
Most importantly of all, there are Trump's own words from his speech at the Save America rally on January 6th, where he directly describes the Eastman plan multiple times.
I'll tell you, thank you very much, John. Fantastic job. I watched. That's a tough act to follow, those two. John is one of the most brilliant lawyers in the country, and he looked at this and he said, what an absolute disgrace that this could be happening to our Constitution. And he looked at Mike Pence, and I hope Mike is going to do the right thing. I hope so. I hope so. Because if Mike Pence does the right thing, we win the election. All he has to do, this is from the number one, or certainly one of the top constitutional lawyers in our country. He has the absolute right to do it. We're supposed to protect our country, support our Constitution, and protect our Constitution. States want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. They want it back. All Vice President Pence has to do is send it back to the states to recertify. And we become president, and you are the happiest people. And Mike Pence is going to have to come through for us. And if he doesn't, that will be a sad day for our country, because you're sworn to uphold our Constitution. We have come to demand that Congress do the right thing and only count the electors who have been lawfully slated. And Mike Pence, I hope you're going to stand up for the good of our Constitution and for the good of our country. And if you're not, I'm going to be very disappointed in you. I will tell you right now. I'm not hearing good stories. So I hope Mike has the courage to do what he has to do. And I hope he doesn't listen to the rhinos and the stupid people that he's listening to.
When Trump mentions Mike Pence coming through for us repeatedly, he's referring to the entire plan hinging on Pence asserting the powers that Eastman, Chesebro, and Raiklin claim the VP has at his disposal to unilaterally reject electors. In fact, it's Trump's interactions with Pence over the course of this whole ordeal that are probably the most damning bits of evidence against the idea that Trump just didn't know what was going on. Pence was interviewed by the January 6th special counsel, Jack Smith. He laid out a separate timeline of Trump's actions, both public and private, where Trump would try and pressure him to adhere to the Eastman scheme and overturn the vote. On November 4th, 2020, Trump asked Pence to study up on voter fraud claims in preparation for legal challenges. Pence recalled the conversation as being broad. It was just, look at all of it. Let me know what you think. But the campaign is going to fight, going to go to court and make challenges. And then he just said we're going to fight this and take a look at it. Let me know what you think. On November 7th, as projections made it clear that Biden was the winner, Pence tried to cheer Trump up as a friend, telling him, "You took a dying political party and gave it a new lease on life." On November 12th, campaign lawyers gave Trump, Pence, and campaign and White House staff a pessimistic report on the state of the election legal challenges. On that same day during lunch, Pence recommended to Trump, "Don't concede, but recognize the process is over." On November 16th, again during lunch, Pence tried to encourage Trump to accept the results and run again in 2024, which Trump brushed off as being so far off. On November 23rd, Trump told Pence that his private lawyer was not optimistic about the ongoing challenges. It's after this point that Chesebro begins to float the initial ideas that would eventually become the Eastman scheme. Pence wrote in his autobiography, So Help Me God, that the first time he heard Trump mention anything like the Eastman scheme was on a phone call on December 5th, though no names or concrete plans were mentioned. When Trump retweeted Raiklin's Operation Pence card tweet, Pence recalled that he showed it to his wife and rolled his eyes. Greg Jacob, the chief legal counsel to the vice president, testified to Congress under oath that eventually the idea reached the vice president's office, and Pence came to him seeking legal clarification.
The first time that I had a conversation with the vice president about the 12th Amendment and the Electoral Count Act was in early December, around December 7th. The vice president called me over to his West Wing office and told me that he had been seeing and reading things that suggested that he had a significant role to play on January 6th in announcing the outcome of the election. He told me that he had been first elected to Congress in 2000 and that one of his earliest memories as a congressman was sitting in on the 2001 certification, and he recalled that Al Gore had gavelled down a number of objections that had been raised to Florida. And he asked me mechanically, how does this work at the joint session? What are the rules? And I told the vice president that, in fact, I had a fairly good idea of how things work, that actually there aren't rules that govern the joint session, but what there is a provision of the Constitution that's just one sentence long, and then an Electoral Count Act that had been passed in 1887. And I told the vice president that I could put a memo together for him overnight that would explain the applicable rules.
So, Mr. Jacobs, when you looked at this theory, what did you conclude?
So we concluded that what you have is a sentence in the Constitution that is inartfully drafted. But the vice president's first instinct when he heard this theory was that there was no way that our framers, who abhorred concentrated power, who had broken away from the tyranny of George III, would ever have put one person, particularly not a person who had a direct interest in the outcome because they were on the ticket for the election, in a role to have decisive impact on the outcome of the election. And our review of text, history, and frankly just common sense all confirmed the vice president's first instinct on that point. There is no justifiable basis to conclude that the vice president has that kind of authority.
On December 21st, Pence tried to encourage Trump to not look at 2020 as a loss but an intermission. Trump asked him, "What should we do?" And Pence responded, "After we've exhausted every legal process, if we still come up short, you should take a bow." On December 25th, Pence called Trump to wish him a Merry Christmas, but Trump immediately turned the conversation to the election and asked Pence to trust the plan. Pence replied with, "You know I don't think I have the authority to change the outcome," alluding to various previous conversations they'd had during December. On December 29th, Trump told Pence the Justice Department was finding major infractions, a claim which was not true. On January 1st, Trump called Pence again and berated him for opposing a lawsuit that was seeking to establish that the VP could toss electors. Pence responded by saying there was no constitutional basis, and furthermore, it was improper. Trump told him he was being too honest. I think this is referring to the Gohmert lawsuit, where House Rep. Louis Gohmert was seeking to have the court declare that the VP can unilaterally decide which electors to count and which to toss. Gohmert's a name that'll come up a little bit later in the story. On January 3rd, Trump once again called Pence to make the claim that the VP had the absolute right to reject the electors, and Pence once again responded he had no such authority. And good God, talking to Trump during this month must have been fucking aggravating. On January 4th, Pence had another meeting to discuss the issue once again, which Jacob described in detail under oath.
When the Vice President returned to Washington, he was summoned to meet with the President regarding the upcoming joint session of Congress. Mr. Jacob, who attended that meeting?
The attendees were the Vice President, the President, Mark Short, the Chief of Staff to the Vice President, myself, and John Eastman. There was about a 5-minute period where Mark Meadows came in on a different issue.
Let's show a photo of that meeting. Mr. Jacob, during that meeting between the President and the Vice President, what theories did Dr. Eastman present regarding the role of the Vice President in counting the electoral votes?
During the meeting on January 4th, Mr. Eastman was opining that there were 2 legally viable arguments as to authorities that the Vice President could exercise 2 days later on January 6th. One of them was that he could reject electoral votes outright. The other was that he could use his capacity as presiding officer to suspend the proceedings and declare essentially a 10-day recess during which states that he deemed to be disputed, there was a list of 5 to 7 states that the exact number changed from conversation to conversation, but that the Vice President could sort of issue a demand to the state legislatures in those states to re-examine the election and declare who had won each of those states. So he said that both of those were legally viable options. He said that he did not recommend, upon questioning, he did not recommend what he called the more aggressive option, which was reject outright, because he thought that that would be less politically palatable. The imprimatur of state legislature authority would be necessary to ultimately have public acceptance of an outcome in favor of President Trump, and so he advocated that the preferred course of action would be the procedural route of suspending the joint session and sending the election back to the states.
Mr. Jacob, I know you won't discuss the direct conversations between the President and the Vice President, so rather than asking you what the Vice President said in that meeting, I'll ask you a more general question. Did the Vice President ever waver in his position that he could not unilaterally decide which electors to accept?
The Vice President never budged from the position that I have described as his first instinct, which was that it just made no sense from everything that he knew and had studied about our Constitution that one person would have that kind of authority.
And did the Vice President ever waver in his position that he could not delay certification and send it back to the states?
No, he did not.
According to Pence's notes of this meeting, Trump would once again repeat claims that he had actually won, at one point even claiming he won all 50 states. All of the claims Trump made in this meeting, his own Justice Department had previously told him were not true. Trump and Eastman once again reiterated to Pence that he should either directly reject the electors and unilaterally install Trump as president, or he should send the dueling electors back to the legislatures of the states they had come from and ask them to determine which one was correct. Pence asked Eastman if this was legally possible, and Eastman replied, "Nobody's tested it before." Pence then exclaimed, "Even your own counsel is not saying I have the authority to do this." And Trump replied, "That's okay, I prefer the other suggestion, the one where he was simply installed as president." At 11 a.m. on January 5th, Trump publicly tweeted that Pence had the power to reject electors, in defiance of the content of the previous day's meeting on the matter. At the same time, Jacob met with Eastman again, which he also described under oath.
Can you tell us a little bit more about that meeting with Dr. Eastman on January 5th? For example, where was the meeting? Who was there?
So at the conclusion of the meeting on the 4th, the president had asked that our office meet with Mr. Eastman the next day to hear more about the positions he had expressed at that meeting, and the vice president indicated that sort of offered me up as his counsel to fulfill that duty. So we met in Mark Short's office in the executive office building across the way from the White House. Dr. Eastman had a court hearing by Zoom that morning, so it didn't start first thing, but rather started around 11. And that meeting went for about an hour and a half, 2 hours. Chief of Staff Mark Short was at that meeting most of the time. There were a few times that he left. And essentially it was an extended discussion. What most surprised me about that meeting was that when Mr. Eastman came in, he said, "I'm here to request that you reject the electors." So on the 4th, that had been the path that he had said, "I'm not recommending that you do that." But on the 5th, he came in and expressly requested that. And I grabbed a notebook as I was heading into the meeting. I didn't hear much new from him to record, but that was the first thing I recorded in my notes, was request that the VP reject.
Just to be clear, you're saying that Dr. Eastman urged the vice president to adopt the very same approach that Dr. Eastman appeared to abandon in the Oval Office meeting with the president the day before. Is that correct?
He had recommended against it the evening before, and then on the 5th came in, and I think it was probably his first words after introductions and as we sat down were, "I'm here to request that you reject the electors in the disputed states."
And you referenced a moment ago some handwritten notes, which you've provided to the Select Committee. I'd now like to show you those notes. As you can see, you wrote there at the top, the writing's a little bit faint in the copy, but you wrote, "Requesting VP reject." Does that accurately reflect what Dr. Eastman asked of you in your meeting on January 5th?
Yes.
And what was your reaction when Dr. Eastman said on January 5th that he was there to ask the Vice President of the United States to reject electors at the joint session of Congress?
I was surprised because I had viewed it as sort of one of the key concessions that we had secured the night before from Mr. Eastman that that he was not recommending that we do that.
So what did you say to him?
Well, as I indicated, to some extent it simplified my task because there are more procedural complexities to the send it back to the states point of view, and I actually had spent most of my evening the night before writing a memorandum to the Vice President explaining all of the specific provisions of the Electoral Count Act that plan would violate. So instead, since he was pushing the sort of robust unilateral power theory, I've already walked the committee through the discussions that we had. I started out with our points of commonality, or what I thought were our points of commonality. We're conservatives, we're small government people, we believe in originalism as the means by which we're going to interpret this. And so we walked through the text, we walked through the history. He again tried to say, but I don't think the courts will get involved in this. They'll invoke the political question doctrine, and so if the courts stay out of it, that will mean that we'll have the 10 days for the states to weigh in and resolve it, and then they'll send back the Trump slates of electors, and the people will be able to accept that. And I expressed my vociferous disagreement with that point. I did not think that this was a political question. among other things, if the courts did not step in to resolve this, there was nobody else to resolve it. You would be in a situation where you have a standoff between the President of the United States and, counterfactually, the Vice President of the United States, saying that we've exercised authorities that constitutionally we think we have, by which we have deemed ourselves the winners of the election. You would have an opposed House and Senate disagreeing with that. So you would have had just an unprecedented constitutional jump ball situation with that standoff. And as I expressed to him, that issue might well then have to be decided in the streets. Because if we can't work it out politically, we've already seen how charged up people are about this election. And so it would be a disastrous situation to be in. So I said, I think the courts will intervene. I do not see a commitment in the Constitution of the question whether the Vice President has that authority to some other actor to resolve. There's arguments about whether Congress and the Vice President jointly have a constitutional commitment to generally decide electoral vote issues. I don't think that they have any authority to object or reject them. I don't see it in the 12th Amendment, but nonetheless. And I concluded by saying, John, in light of everything that we've discussed, can't we just both agree that this is a terrible idea? And he couldn't quite bring himself to say yes to that, but he very clearly said, well, yeah, I see we're not going to be able to persuade you to do this. And that was how the meeting concluded.
After this, Trump and Pence had a private one-on-one meeting. Jacob wasn't privy to what went on in that meeting, but he did describe the lead up to it.
So after my extended meeting with Mr. Eastman that morning, during that time, the Vice President had been back at his residence working on his statement to the nation that we released the next day. He got down to the White House some point between 1 o'clock and 2 o'clock as my meeting with Mr. Eastman was wrapping up. And when Mark Short and I went over to meet with the Vice President, and actually we thought maybe we had good news. We felt like we had sort of defeated Mr. Eastman, that he was sort of acknowledging that there was no there. But the Vice President was then asked down to the Oval Office, and he went down to the Oval Office while Mark and I stayed back in the Vice President's office.
You weren't in that meeting.
I was not.
During this private meeting, Trump asked of Pence the same question for the 1,000th time, and Pence gave the same answer: no. At this, Trump became frustrated and told Pence he would have to publicly criticize him for his disloyalty. Two Washington Post reporters, Bob Woodward and Robert Costa, used Pence's notes of this meeting in their book, Peril. Costa described the conversation as Pence transcribed it in an interview on NPR.
And he was also under intense pressure. The scene in the book, January 5th, hours before the insurrection on January 6th, in the Oval Office with President Trump, the temptation of power. President Trump says to Vice President Pence, based on our reporting, wouldn't it be cool to have the power to stop a certification of an election? Wouldn't it be great if these people outside in the streets wanted you to do it? Do it for me, Mike. Do it for me.
In the book, the conversation's even more striking. Its contents was repeated in Congress, which will save me the trouble of having to record it myself, so let's listen.
Journalists Bob Woodward and Robert Costa write that the president said, quote, "If these people say you have the power, wouldn't you want to?" The vice president says, quote, "I wouldn't want any one person to have that authority." The president responds, "But wouldn't it almost be cool to have that power?" The vice president is reported to have said, "No, look, I've read this, and I don't see a way to do it. We've exhausted every option. I've done everything I could and then some to find a way around this. It's simply not possible. My interpretation is no." To which the president says, "No, no, no. You don't understand, Mike. You can do this. I don't want to be your friend anymore if you don't do this."
Now, as far as I know, Pence's notes have not been made public, and this exchange did not appear in Pence's description of the meeting in his interview with Jack Smith. Unlike everything else so far, which has been said under oath and corroborated by multiple witnesses, it is entirely possible that Woodward and Costa made this exchange up. So let's take it with a grain of salt. However, Mike Pence did repeat the language that Woodward and Costa claimed he used to Mark Short, his chief of staff.
In other conversations with the vice president, he articulated to me that no, he wouldn't want that power bestowed upon any one person.
The bare outline of this meeting did leak to the New York Times, whose article on the event read that Trump had directly pressed Pence to find an alternative to certifying Biden's win, such as preventing him from having 270 votes and throwing it to the House. And Pence and Trump were expected to hear a last-minute pitch from John Eastman, a Trump lawyer, along with other vague statements that imply, but don't outright state, that Pence did not plan to do what Trump wanted him to do. In response to this article, Trump put out this official statement on the evening of the 5th, which reads, "The New York Times report regarding comments that Vice President Pence supposedly made to me today is fake news. He never said that. The Vice President and I are in total agreement that the Vice President has the power to act," which is a statement that is in direct defiance of Pence's consistent, unwavering position. Jacob and Short both testified about the reactions of Pence and his staff to Trump's statement.
Mr. Jacob, how did the vice president's team react to this statement from the president that the vice president could take an active role in determining the winner of the presidential election?
We were shocked and disappointed because whoever had written and put that statement out, it was categorically untrue.
Vice President's Chief of Staff Mark Short had an angry phone call with Trump campaign senior advisor Jason Miller about this statement. Here's what Mr. Short and Mr. Miller told the committee about that call.
Okay. Tell me about the conversation you had with Jason.
It was brief. I was irritated and expressed displeasure that a statement could have gone out that misrepresented the vice president's viewpoint without consultation.
The statement says the vice president and I are in total agreement that the vice president has the power to act. Is that incorrect?
I think the record shows that that's incorrect.
Yeah.
I mean, we've been through many documents that clarify that this is not where the vice president was.
Right. So essentially, the president is sending out a baldly false statement about being in alignment, purported alignment with the vice president, despite all of the predicate that you indicated had gone before about their respective positions. Is that effectively what happened?
I interpret the statement as false. I'll let you figure out who sent it out.
When Mark Short contacted you, he was upset. Is that what you said?
He clearly was not pleased.
Tell us what he said.
What's the process for putting out a statement for a meeting where only two people were in the room?
Did he ask you to retract the statement?
No, I think it went right to what's the process for putting out a statement for a meeting when only two people were in the room.
And he clearly disagreed with the substance, though, right? Because he said the vice president doesn't agree with this.
Trying to think what exactly he said. I mean, the tone was very clearly that he used some language to strongly infer that the vice president disagreed with that take, but I don't remember what that language was.
Did he dictate this statement?
He dictated most of it. I mean, typically on these, I might have a couple of wording suggestions, or maybe I, have a sentence or a rough framework or something of that. But I know with specificity on this one that it was me and him on the phone talking through it, and ultimately the way this came out was the way that he wanted to.
In the early morning hours of January 6th, Trump tweeted the following: "If Pence comes through for us, we will win the presidency. Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back. States want to correct their votes, which they now know were based on irregularities and fraud, plus corrupt process that never received legislative approval. All Mike Pence has to do is send them back to the states and we win. Do it, Mike. This is a time for extreme courage." At 11:15 a.m., Trump called Pence one final time. Pence, once again, refused. It's at this point that Trump inserted language into his Save America speech, which he would give within the hour, exclaiming that only Mike Pence could save the republic. Those are the clips I showed you earlier. And to be honest, this last-minute insertion explains why the speech feels a bit unfocused. If you go back and watch the whole thing for yourself, you'll notice that Trump focuses in on specific states for a few minutes, but then randomly jumps back to Mike Pence and the electors at odd moments. All throughout December and early January, while these private meetings were taking place, Trump regularly made public statements about Mike Pence's role to play and how Pence has to come through for him, similar to the statements that he made during his Save America rally speech on January 6th.
I hope Mike Pence comes through for us, I have to tell you. I hope that our great vice president comes through for us. He's a great guy. Of course, if he doesn't come through, I won't like him quite as much.
Was it your impression that the vice president had directly conveyed his position on these issues to the president, not just to the world through a Dear Colleague letter, but directly to President Trump?
Many times.
And had been consistent in conveying his position to the president?
Very consistent.
I am aware of the fact that the president was upset with the way Pence acted.
Are we to assume that this is going to be a climactic battle?
Well, I think a lot of that depends on the courage and the spine of the individuals involved.
That would be a nice way to say a guy named Vice President Mike Pence?
Yes.
I think we've been clear as to what the vice president's role was. I think the vice president been clear with the president. I think I've been clear with Mark Meadows.
I think the vice president is going to throw down tomorrow and do the right thing because, Lou, like I said before, this is a time for choosing. People are going to look back at this moment tomorrow and remember where every single one of their elected officials were. Did they vote for the rule of law and getting these elections right, or did they give it away to the Democrats and the people who cheated and stole their way through this election?
Definitely in the, when I got back into town, as we talk, say, like the 5th and the 6th, the president was, all the attention was on what Mike would do or what Mike wouldn't do.
The vice president really was not wavering in his commitment to what his responsibility was.
So, this wasn't simply some crackpot idea that Eastman or Chesebro cooked up, and Trump simply had no knowledge of what was going on. Trump actively supported and contributed to the Eastman plot. He repeatedly and consistently pressured Mike Pence, both in private and in public, to perform actions that he had been repeatedly told by multiple legal counsels were illegal, in the hopes that Pence would give in and reject legitimate Electoral College votes for Biden. Though Pence described himself as Trump's good friend on Election Day 2020, Trump's constant pressure on Pence to violate the Constitution destroyed that friendship. Okay, well, the next thing to ask is the Eastman scheme actually illegal? Yeah, to a layman like you or I, it might not pass the sniff test, but legally, who knows? Well, apparently, Trump and his team knew. As the scheme picked up steam, Justin Clark and Matt Morgan, two lawyers for the Trump campaign, thought that it wasn't legal and decided to bow out.
I just remember I either replied or called somebody saying, unless we have litigation pending that's like in these states, like, I don't think this is appropriate, or, this isn't the right thing to do. I don't remember how I phrased it, but, and I got into a little bit of a back and forth, and I think it was with Ken Chesebro, where I said, all right, you just get after it. Like, I'm out.
At that point, I had Josh Finley email Mr. Chesebro politely to say, this is your task. You are responsible for the Electoral College issues moving forward. And this was my way of taking that responsibility to zero.
As recounts and investigations and court cases continued to unearth little evidence of Trump's fraud claims, which was the justification for the creation of the alternate electors, as you recall. Bill Steppen, Trump's campaign manager, described how Trump's legal staff did not want to get involved, and so Trump gutted them and replaced them with Giuliani.
I think the president, it was during the second week where things like you displayed were occurring, where he was growing increasingly unhappy with his team, me less so because I was less involved at this point, but still me, growing increasingly unhappy with Justin Clark, and that kind of paved the way for Justin to be moved out and Mayor Giuliani to be moved in as the person in charge of the legal side of the campaign, and for all intents and purposes, the campaign at that point.
As a result of this, Stepien also decided to bow out.
And was it important for you, Mr. Stepien, to sort of pull back just for your own professional reputation? You didn't want to be associated with some of what you were hearing from the Giuliani team and others that sort of stepped in the wake of your departure?
I didn't mind being categorized. There were two groups of, we called them kind of my team and Rudy's team. I didn't mind being characterized as being part of Team Normal, as reporters, kind of started to do around that point in time. I said, hours ago, early on that, I've been doing this for a long time, 25 years, and I've spanned, political ideologies from Trump to McCain to Bush to Christie, and, I can work under a lot of circumstances for a lot of varied, candidates and politicians, but situation where, and I think along the way I've built up a pretty good, I hope, a good reputation for being honest and professional, and I didn't think what was happening was necessarily honest or professional at that point in time. So that led to me stepping away.
Morgan testified that Trump couldn't find a law firm willing to make the arguments that Giuliani was making.
I think I had conversations with probably all of our counsel who are signed up to assist on Election Day as they disengaged with the campaign. The general consensus was that the law firms were not comfortable making the arguments that Rudy Giuliani was making publicly. I seem to recall that I had a similar conversation with most all of them.
Mike Pompeo, Trump's Secretary of State, testified to Congress under oath that he told Trump his view that once the court cases all failed, it was time to pack it up.
So once the courts had ruled and the Electoral College had met, the election was over in your view?
Yes, I think I've said previously that when the vice president made the certification and the litigation was complete, it was complete.
When the Electoral College met on the 14th?
Yes, as of December 14th, is that right? I think that's the right date, yes.
Judd Deere, Trump's deputy press secretary, testified to Congress under oath basically the same thing.
I told him that my personal viewpoint was that the Electoral College had met, which is the system that our country is set under to elect a president and vice president. And I believed at that point that the means for him to pursue litigation was probably closed.
And do you recall what his response, if any, was?
He disagreed.
Eugene Scalia, Trump's Secretary of Labor, testified the same thing.
And so I had to put a call into the president. I might have called on the 13th. We spoke, I believe, on the 14th, in which I conveyed to him that I thought that it was time for him to acknowledge that President Biden had prevailed in the election. But I communicated to the president that when that legal process is exhausted and when the electors have voted, that's the point at which that outcome needs to be expected. I told him that I did believe, yes, that once those legal processes were run, if fraud had not been established that had affected the outcome of the election, then unfortunately I believed that what had to be done was concede the outcome.
Pat Cipollone, chief legal counsel to the president, told Trump directly that the Eastman scheme was not legally viable.
Pat Cipollone thought the idea was nutty and had at one point confronted Eastman basically with the same sentiment.
Pat expressed his admiration for the vice president's actions on the day of the 6th and said that he concurred with the legal analysis that our team had put together to reach that point.
In fact, due to Cipollone's consistent pushback of the scheme, he found himself on the outside of Trump's inner circle, replaced at official meetings by Eastman. After January 6th, as Trump faced mass resignations from his cabinet, Cipollone testified to Congress under oath that he also considered walking out like his colleagues, but ultimately decided against it, because he knew that if he walked, his official position, with all of its legal powers, would be filled by Trump with somebody like John Eastman.
After that, some people were resigning, obviously, over January 6th. We know who they were. Did I consider it? Yes. Did I do it? No. Concerned about is if people in the counsel's office left, who would replace me? And I had some concerns that it might be somebody who, had been giving bad advice.
Stephen Engel, the head of the Office of Legal Counsel, testified to Congress under oath about how Trump brought in outside lawyers to draft lawsuits that his department was expected to file when he wasn't getting the legal results he wanted.
The president sent a draft lawsuit to be filed by the department in the Supreme Court. He wanted you, Mr. Rosen, and Mr. Cipollone specifically to review it. You and the department opposed filing it. We see on the screen here that the talking points that you actually drafted on that. So you stated that there is no legal basis to bring this lawsuit. Anyone who thinks otherwise simply doesn't know the law, much less the Supreme Court. Why was this the department's position?
Well, I mean, I think that it was the memo sort of speaks to this, but essentially this was a draft lawsuit that apparently was prepared by people outside the department. It would be styled as brought by the United States and by the acting Solicitor General as an original jurisdiction matter in the Supreme Court. It was a meritless lawsuit that was not something that the department could or would bring. Somebody obviously prepared it, handed it to the president, and he forwarded it on for our review. But that memo explains why the Department of Justice, as Mr. Donahue said earlier, doesn't have any standing to bring such a lawsuit. The lawsuit would have been untimely. The states had chosen their electors. The electors had been certified. They'd cast their votes. They'd been sent to Washington, D.C. Neither Georgia nor any of the other states on December 28th or whenever this was in a position to change those votes. Essentially, the election had happened. The only thing that hadn't happened was the formal counting of the votes. And so obviously, the person who drafted this lawsuit didn't really understand, in my view, the law and or how the Supreme Court works or the Department of Justice. So it was just not something we were going to do. And the acting Attorney General asked me to prepare a memo with talking points so that he could explain our reasons when he spoke with the president about this.
So would you say it was an unusual request?
It was certainly you said the request that the department file a lawsuit from drafted by outside lawyers was certainly an unusual request.
Engel's office also told Giuliani and Mark Meadows that the Eastman scheme was not legally sound.
And so to be clear, did you hear the White House counsel's office say that this plan to have alternate electors meet and cast votes for Donald Trump in states that he had lost was not legally sound?
Yes, sir.
And who was present for that meeting that you remember?
It was in our office. It was Mr. Meadows, Mr. Giuliani, and a few of Mr. Giuliani's associates.
Eric Hirschman, a lawyer working for the White House, testified to Congress under oath that he debated the topic with Giuliani on the morning of January 6th, and Giuliani ultimately admitted to him that no court would agree with him.
The morning of January 6th, I think he called me out of the blue, right? And I was getting dressed, and we had an intellectual discussion about Eastman's, I don't know if it's Eastman's theory per se, but the VP's role. And he was asking me my view and analysis and then the practical implications of it. And when we finished, he said, I believe that, you're probably right. I think he thought when we're done that it would be something he'd have to consider if he was sitting on the bench. But he'd probably come down in that, you couldn't interpret it or sustain the argument long term. It made no sense to me that in all the protections that were built into the Constitution for a president to get elected and steps that had to be taken, that the power to choose the next president would be sitting with the vice president.
Despite this, Giuliani still claimed a couple of hours later, during his Save America rally speech, that what they planned to do was entirely legal.
Every single thing that has been outlined as the plan for today is perfectly legal. I have Professor Eastman here with me to say a few words about that. He's one of the preeminent constitutional scholars in the United States.
According to Short, Mark Meadows would do the same sort of thing. Concede the point in one conversation, and then just forget and keep it up in the next.
You've been clear repeatedly with Mr. Meadows about you and the vice president having a different view about his authority on January 6th.
I believe I had.
Did Mr. Meadows ever explicitly or tacitly agree with you or say, yeah, that makes sense or okay?
I believe that that Mark did agree.
What makes you say that?
I believe that's what he told me, but as I mentioned, I think Mark had told so many people so many different things that it was not something that I would necessarily accept as, okay, well, that means that's resolved.
I see. Tell me more what he told you on this topic.
Well, I think it was that, the vice president doesn't have any broader role. And I think he was understanding of that.
So despite the fact that he may have said other things to the president or others, to you, he said he understands the vice president has no role.
Yes.
Okay. Did he say that to you several times?
A couple times.
Mm-hmm. Before January 6th?
Yes.
Eastman did the exact same thing. During his debate with Greg Jacob on the issue, Eastman himself admitted his plan was not legal.
So during that meeting on the 4th, I think I raised the problem that both of Mr. Eastman's proposals would violate several provisions of the Electoral Count Act. Mr. Eastman acknowledged that that was the case, that even what he viewed as the more politically palatable option would violate several provisions, but he thought that we could do so because in his view the Electoral Count Act was unconstitutional, and when I raised concerns that that position would likely lose in court, his view was that the court simply wouldn't get involved. They would invoke the political question doctrine, and therefore we could have some comfort proceeding with that path.
Mr. Wood?
But just to reiterate, he told you, maybe this was in a later conversation, but he told you at some point that if in fact the issue ever got to the Supreme Court, his theory would lose 9-0, correct?
The next morning, starting around 11 or 11:30, we met for an hour and a half to 2 hours. And in that meeting, I've already described the text, structure, history conversation, but we started walking through all of that. And I said, so John, basically what you have is some text that may be a little bit ambiguous, but then nothing else that would support it, including the fact that nobody would ever want that to be the rule. Wouldn't we lose 9-0 in the Supreme Court? And again, he initially started, well, maybe you'd only lose 7-2, but ultimately acknowledged that no, we would lose 9-0. No judge would support his argument.
However, Eastman justified his plan by saying that even though it's illegal, sometimes violence is necessary to protect the republic.
What were your prior interactions with Eastman?
He described for me what he thought the ambiguity was in the statute, and he was walking through it at that time. And I said, hold on a second, I want to understand what you're saying. You're saying that you believe the vice president, acting as president of the Senate, can be the sole decision maker as to, under your theory, who becomes the next president of the United States? And you said yes. And I said, are you out of your effing mind? Right? And that was pretty blunt. I said, you're completely crazy. I said, you're going to turn around and tell 78 plus million people in this country that your theory is this is how you're going to invalidate their votes because you think the election was stolen? And I said, they're not going to tolerate that. I said, you're going to cause riots in the streets. And he said, words to the effect of there's been violence in the history of our country, Eric, to protect the democracy or protect the republic.
This debate also played out in an email exchange between Jacob and Eastman, where Jacob continuously cited the Constitution and legal precedent, while Eastman rejected that logic by exclaiming that America was under attack, and so adhering to principle and procedure was small-minded. This exchange continued through the January 6th riot, where Jacob eventually wrote, while hiding from the rioters who had breached the building with Vice President Pence, that although both Jacob and Eastman might not agree with the Democrats' policy platform, there is not a single judge in the country who would agree with Eastman ignoring the law, the Constitution, and 130 years of precedent in this attempt to keep the Democrats out of power. He pointed out that even Judge Ludig, Eastman's own mentor, disagreed with him. Ludig also testified the same to Congress under oath, and was another legal counsel that Pence relied on during this ordeal.
I believe that had Vice President Pence obeyed the orders from his president during the joint session of the Congress of the United States on January 6, 2021, that declaration of Donald Trump as the next president would have plunged America into what I believe would have been tantamount to a revolution within a constitutional crisis, which in my view, and I'm only one man, would have been the first constitutional crisis since the founding of the Republic.
Jacob ended the email with the statement, "Thanks to your bullshit, we are now under siege." Though it's pretty obvious, he explained his meaning here during his testimony.
Mr. Jacob, immediately before you and the Vice President were evacuated to a secure location within the Capitol, you hit send on an email to John Eastman explaining why his legal theory about the Vice President's role was wrong. You ended your email by stating that, quote, "Thanks to your bullshit, we are now under siege." We'll take a look at that email. Now, Dr. Eastman replied, and this is hard to believe, but his reply back to you was, "The siege is because you and your boss," presumably referring to the Vice President of the United States, "did not do what was necessary to allow this to be aired in a public way so the American people can see for themselves what happened." Mr. Jacob, later that day, you wrote again to Dr. Eastman. In that email, you wrote, and I quote, "Did you advise the President that in your professional judgment, the Vice President does not have the power to decide things unilaterally?" And you ended that email saying, "It does not appear that the President ever got the memo." Dr. Eastman then replied, "He's been so advised." And he ends his email with, quote, "But you know him, once he gets something in his head, it's hard to get him to change course," close quote. Mr. Jacob, when Dr. Eastman wrote, "Once he gets something in his head, it's hard to get him to change course," did you understand the he in that email to refer to the President of the United States?
So, despite all of this, despite Eastman being told his plan was against the law, despite him admitting it was against the law, despite him even telling Trump directly it was against the law, they both told the public multiple times what they planned to do, and then they went out and tried to do it.
And all we are demanding of Vice President Pence is this afternoon at 1 o'clock, he let the legislatures of the state look into this.
Most outrageously of all, after the January 6th riot had been quelled and the counting of the Electoral College votes resumed, Eastman actually tried one last time to get his plan off the ground.
And Mr. Jacob, did you hear from Dr. Eastman further after the riot had been quelled? And if so, what did he ask?
Late that evening, after the joint session had been reconvened, the Vice President had given a statement to the nation saying that violence was not going to win, freedom wins, and that the people were going to get back to doing their work. Later that evening, Mr. Eastman emailed me to point out that, in his view, the Vice President's speech to the nation violated the Electoral Count Act, that the Electoral Count Act had been violated because the debate on Arizona had not been completed in 2 hours. Of course, it couldn't be since there was an intervening riot of several hours. And that the speeches that the majority and minority leaders had been allowed to make also violated the Electoral Count Act because they hadn't been counted against the debate time. And then he implored me, now that we have established that the Electoral Count Act isn't so sacrosanct as you have made it out to be, I implore you one last time, can the Vice President please do what we've been asking him to do these last 2 days? Suspend the joint session, send it back to the states.
And we'll show you the text of that email, which Dr. Eastman wrote at 11:44 p.m. on January 6th. So after the attack on the Capitol and after law enforcement had secured the Capitol, he still wrote, as you described, quote, "So now that the precedent has been set that the Electoral Count Act is not quite so sacrosanct as was previously claimed, I implore you to consider one more relatively minor violation and adjourn for 10 days to allow the legislatures to finish their investigations. So even after the attack on the Capitol had been quelled, Dr. Eastman requested, in writing no less, that the vice president violate the law by delaying the certification and sending the question back to the states. Is that correct, Mr. Jacob?
It is.
Did you eventually share Dr. Eastman's proposal with Vice President Pence?
Not right at that time, because the vice president was completing the work that it was his duty to do. But a day or two later, back at the White House, I did show him that final email from Mr. Eastman.
And what was Vice President Pence's reaction when you showed him the email where Dr. Eastman, after the attack on the Capitol, still asked that the vice president delay certification and send it back to the states?
He said, that's rubber room stuff.
By rubber room stuff, Pence means that Eastman is insane. A rubber room is an old-timey expression for a padded cell in an asylum. In the aftermath of January 6th, multiple members of Trump's staff began to ask Trump for preemptive presidential pardons for their actions in assisting with the Eastman scheme, which is the kind of thing you only do if you believe you broke the law.
Did Rudy Giuliani ever suggest that he was interested in receiving a presidential pardon related to January 6th?
He did.
Ms. Hutchison, did White House Chief of Staff Mark Meadows ever indicate that he was interested in receiving a presidential pardon related to January 6th?
Mr. Meadows did seek that pardon. Yes, ma'am.
Anyway, it looks like the Eastman scheme does in fact violate the law. But sometimes Trump supporters say, there's nothing wrong with it. It's just a novel legal theory. That's the phrase they use, novel legal theory. And it has to be the most retarded defense I've ever heard. You know that novel legal theories can still be wrong and illegal, right? You can take wild shots in the dark hoping to swing for the fence, and still end up doing something that lands you and pound you in the ass prison for your troubles. If someone mindlessly parrots the novel legal theory talking point, they probably had their brain surgically removed and replaced with a handful of those silicone Stay Fresh packets. The next commonly asked question is, okay, well, what if Trump legitimately believed he won the election, and all of this stuff was just him and his team trying to set it right? Alright, we can explore that possibility. However, it'll become clear very quickly that the only way for Trump to actually believe this is if he were experiencing a psychotic break or something. It wasn't just Pence who gave Trump significant pushback. Stepan told him he lost.
What was your view on the state of the election at that point?
Very, very, very bleak. We told him, the group that went over there outlined, my belief in chances for success at this point, and then we pegged it at 5, maybe 10% based on recounts that were either were automatically initiated or could be initiated. Based on, realistic legal challenges, not all the legal challenges that eventually were pursued. But it was, my belief is that it was a very, 5 to 10%. It's not a very good, optimistic outlook.
Hirschman told him he lost.
The Dominion stuff was, I never saw any evidence whatsoever to sustain those allegations. What they were proposing, I thought was nuts. And the theory was also completely nuts, right? It was a combination of Italians, Germans. Different things have been floating around as to who was involved. I remember Hugo Chavez and a Venezuelan. She has an affidavit from somebody who says they wrote a software in and something with the Philippines, and just all over the radar.
Miller told him he lost.
Do you know if anybody ever told the president that he had lost and that there wasn't a chance of him winning?
I know that the president, when the networks called it, of course, he was informed about the network decision. That afternoon, at some point, myself and a handful of other folks went over and sat down with the president and communicated that the odds of us prevailing in legal challenges were very small.
Cipollone told him he lost.
The question is, did I believe he should concede the election at a point in time? Yes, I did.
Morgan, Short, and Jacob all told him he lost.
Generally discussed on that topic was whether the
fraud, maladministration, abuse, or irregularities, if aggregated and read most favorably to the campaign, would that be outcome determinative? And I think everyone's assessment in the room, at least amongst the staff, Mark Short, myself, and Greg Jacob, was that it was not sufficient to be outcome determinative.
Matt Ozowski, the Trump campaign's top data scientist, told him he had lost.
I was in the Oval Office, and at some point in the conversation, Matt Oskowski, who is the lead data person, was brought on, and I remember he delivered to the president pretty blunt terms that he was going to lose.
And that was based, Mr. Miller, on Matt and the data team's assessment of the sort of county by county, state by state results as reported?
Correct.
Alex Cannon, a Trump campaign lawyer, said there was no fraud.
I recall him asking me questions about Dominion and maybe some other categories of allegations of voter fraud. And I remember telling him that I didn't believe the Dominion allegations because I thought the hand recount in Georgia would resolve any issues with a technology problem and with Dominion or Dominion flipping votes. And I mentioned at that time that the CISA, Chris Krebs, had recently released a report saying that the election was secure. And I believe Mr. Navarro accused me of being an agent of the deep state working with Chris Krebs against the president.
Kellyanne Conway, Trump's counselor, wrote in her memoirs she had told Trump directly he lost. Ken Block, a data expert hired by the Trump campaign to find evidence of fraud, found no evidence.
One of the two companies that they mentioned was mine, as having been hired by the Trump campaign to look for fraud. And I can't remember his exact language, but the basic gist of it was overwhelmingly unable to document any substantial amounts of fraud. Both companies failed to identify substantial amounts of fraud. And the other mention deals with a claim of fraud in Nevada that was supposed to be filed, that I had been asked by the campaign to vet the finding, and I was able to show that the claimed 16,000 duplicate votes was more like 16 duplicate votes. And all of that was documented in emails. All those emails are in the hands of prosecutors in both Georgia and in D.C.
Derek Lyons, another former counselor, was present during one of the many times that Trump's staff told him he lost.
A month and a half or so after the election day. And at that meeting, various allegations of fraud were discussed. And Eric and Pat didn't, told the group, the president included, that none of those allegations had been substantiated to the point where they could be the basis for any litigation challenge to the election.
Brad Raffensperger told him on that famous phone call that the fraud claims just weren't true.
Mr. President, the challenge that you have is the data you have is wrong. We talked to the congressmen, and they were surprised, but I guess there was a person named Mr. Raynard that came to these meetings and presented data. And he said that there was dead people, I believe it was upward of 5,000. The actual number were two people that were dead that voted. We've had several lawsuits, and we've had to respond in court to the lawsuits and the contentions. We don't agree that you have one. I didn't agree about the 200,000 number that you mentioned. And I could go through that point by point. What we had done is we gave our state senate about 1.5 hours of our time going through the election issue by issue. And then on the state house, the government affairs committee, we gave them about 2.5 hours of our time, going back point by point on all the issues of contention. And then just a few days ago, we met with our U.S. congressman, Republican congressman, and we gave them about 2 hours of our time talking about this past election. We did a hand retally, a 100% retally of all the ballots and compared that to what the machine said, and it came up with virtually the same result. Then we did the recount, and we got virtually the same result.
Additionally, Raffensperger would later testify to Congress under oath that he understood some of Trump's comments on that phone call to be veiled threats if he didn't go along with the Eastman scheme.
And I watched you this morning, and you said, well, there was no criminality, but I mean, all of this stuff is very dangerous stuff. When you talk about no criminality, I think it's very dangerous for you to say that.
Secretary Raffensperger, you wrote about this in your book, and you said, quote, "I felt then and still believe today that this was a threat. Others obviously thought so too, because some of Trump's more radical followers have responded as if it was their duty to carry out this threat. Please tell us what you, your wife, even your daughter-in-law experienced regarding threats from Trump's more radical followers."
Well, after the election, my email, my cell phone was doxxed, and so I was getting text all over the country, and then eventually my wife started getting the text, and hers typically came in as sexualized texts, which were disgusting. You have to understand that Trish and I, we met in high school, and we've been married over 40 years now, and so they started going after her, I think, just to probably put pressure on me. Why don't you just quit, walk away? And so that happened, and then some people broke into my daughter-in-law's home, and my son has passed, and she's a widow and has 2 kids. And so we're very concerned about her safety also.
And Mr. Secretary, why didn't you just quit and walk away?
Because I knew that we had followed the law and we had followed the Constitution. And I think sometimes moments require you to stand up and just take the shots. You're doing your job. And that's all we did. You know, we just followed the law and we followed the Constitution. And at the end of the day, President Trump came up short. But I had to be faithful to the Constitution. And that's what I swore an oath to do.
And most notably, Trump's own Department of Justice staff repeatedly and consistently told him he lost. Bill Barr, Trump's Attorney General of the DOJ, told Trump repeatedly he'd investigated and found no evidence of fraud.
The president said there had been major fraud, and that as soon as the facts were out, the results of the election would be reversed. And he went on this for quite a while, as he's prone to do. And then he got to something that I was expecting, which is to say that apparently the Department of Justice doesn't think that it has a role of looking into these fraud claims. So I said, you know, that has to be the campaign that raises that with the state. The department doesn't take side in elections, and the department is not an extension of your legal team. And our role is to investigate fraud, and we'll look at something if it's specific, credible, and could have affected the outcome of the election, and we're doing that. And it's just not. They're just not meritorious. They're not panning out.
Ivanka Trump, his own daughter, prepared to move out of the White House after Election Day, stating that she believed Barr's testimony.
How did that affect your perspective about the election when Attorney General Barr made that statement?
It affected my perspective. I respect Attorney General Barr. So I accepted what he was saying.
Jeff Rosen, the acting Attorney General who replaced Barr, told him the same thing after his own investigations.
Other than try to address a counterfactual or a hypothetical, let me just say there were instances where the president would say, people are telling me this, or I've heard this, or I saw on television, you know, this impropriety in Atlanta or Pennsylvania or something. And we were in a position to say, our people have already looked at that, and we know that you're getting bad information, that's not correct. It's been demonstrated to be incorrect from our point of view, and been debunked.
Richard Donahue, Trump's acting deputy attorney general, told him he was being fed faulty information about fraud.
I tried to, again, put this in perspective and to try to put it in very clear terms to the president. And I said something to the effect of, sir, we've done dozens of investigations, hundreds of interviews. The major allegations are not supported by the evidence developed. We've looked at Georgia, Pennsylvania, Michigan, Nevada. We're doing our job. Much of the info you're getting is false. And then I went into, for instance, this thing from Michigan, this report about 68% error rate. Reality is it was only 0.0063% error rate, less than 1 in 15,000. So the president accepted that. He said, okay, fine, but what about the others? And again, this gets back to the point that there were so many of these allegations that when you gave him a very direct answer on one of them, he wouldn't fight us on it, but he would move to another allegation. I told the president myself that several times in several conversations, that these allegations about ballots being smuggled in a suitcase and run through the machine several times, it was not true. That we looked at the video, we interviewed the witnesses, it was not true.
11 of the judges that ruled on Trump's cases were all Trump appointees.
A federal appeals court in Pennsylvania wrote, quote, "Charges require specific allegations and proof. We have neither here." A federal judge in Wisconsin wrote, quote, "The court has allowed the former president the chance to make his case, and he has lost on the merits." Another judge in Michigan called the claims, quote, "nothing but speculation and conjecture that votes for President Trump were either destroyed, discarded, or switched to votes for Vice President Biden." A federal judge in Michigan sanctioned 9 attorneys, including Sidney Powell, for making frivolous allegations in an election fraud case, describing the case as a historic and profound abuse of the judicial process.
Derek and I both challenged what she was saying. And she says, well, the judges are corrupt. And I was like, everyone? Every single case that you've done in the country you guys lost, every one of them is corrupt? Even the ones we appointed? And I'm being nice. I was much more harsh to her.
A report published by prominent Republican judges and senators titled "Lost, Not Stolen" laid out all of this and stated that Trump and his legal representatives would be disproven in court one day and then blatantly lie to the public the next day, which does seem to be their modus operandi. All of this is to say that Trump absolutely was informed of his loss by everyone around him. He wasn't somehow insulated from the truth. And yet he continued to publicly state the opposite, repeating claims he was already directly told were false. On screen right now are dates where Trump was informed that a claim was false, and then a future date where he publicly repeated the same claim as true. I'm not going to read every single one of them because there are tons of these. You can pause this video and check them out for yourself if you like, but these are all instances where Trump was told directly what he said was false, and he chose to say it anyway. I've even got a video version of this for you. Here's Barr's testimony of a meeting he had with Trump over the Michigan voter fraud claims on December 1st, 2020.
And the president was as mad as I've ever seen him, and he was trying to control himself. And the president said, well, this is, killing me. You didn't have to say this. You must have said this because you hate Trump. You hate Trump. And then he raised the big vote dump, as he called it, in Detroit. And that, he said people saw boxes coming into the counting station at all hours of the morning and so forth. And I explained to him that at that point, I knew the exact number of precincts in Detroit. I think it was 630 something. I said, Mr. President, there are 630 precincts in Detroit, and unlike elsewhere in the state, they centralized the counting process, so they're not counted in each precinct. They're moved to counting stations, and so the normal process would involve boxes coming in at all different hours. So there's nothing. And I said, did anyone point out to you, did all the people complaining about it point out to you, you actually did better in Detroit than you did last time? I mean, there's no indication of fraud in Detroit. And I told him that the stuff that his people were shoveling out to the public was bullshit. I mean, that the claims of fraud were bullshit. And, he was indignant about that. And I reiterated that they'd wasted a whole month on these claims on the Dominion voting machines, and they were idiotic claims. And I specifically raised the Dominion voting machines, which I found to be among the most disturbing allegations. Disturbing in the sense that I saw absolutely zero basis for the allegations, but they were made in such a sensational way that they obviously were influencing a lot of people, members of the public, that there was this systemic corruption in the system and that their votes didn't count and that these machines controlled by somebody else were actually determining it, which was complete nonsense. And it was being laid out there. And I told them that it was crazy stuff and they were wasting their time on that.
And here's Trump on December 2nd, 2020, one day later, repeating the very same claims that Barr already told him were false.
This is Michigan. At 6:31 in the morning, a vote dump of 149,772 votes came in unexpectedly. We were winning by a lot. That batch was received in horror. We have a company that's very suspect. Its name is Dominion. With the turn of a dial or the change of a chip, you can press a button for Trump and the vote goes to Biden. What kind of a system is this?
With all of this laid out, there are only two possibilities that explain Trump's conduct. One, he genuinely believed the election was stolen from him, to the point of actually being psychologically delusional. He consistently rejected the conclusions of audits, recounts, court cases, his own legal counsel, his own attorney general, governors and judges aligned with him politically, and continued to declare himself the victor beyond all reasonable thought, emboldened by worm tongues like Eastman and Chesebro. Suffering from this level of delusion makes him unfit to be president, and I don't know how any self-respecting Trump fan could rally around a person who's clearly lost their mind. The second option is that Trump did know he lost, he simply didn't care. The Constitution, the law, the procedures, they were not the rules of the game that all players abide by in order to make it a fair contest. They were simply obstacles to be rerouted around, with winning as the only aim, whether legitimate or not. So, which is it? Was he delusional or was he a liar? Funnily enough, there's actually evidence for both options. And yes, I have in fact heard Trump supporters during debates fall back on the maybe he's delusional excuse when confronted with evidence of Trump's lies.
Even though everybody in his inner circle was telling him, hey, the Georgia thing, this isn't true. Hey, the Pennsylvania thing, this isn't true. Hey, the ballot boxes, we investigated, that's not true. You don't think that him hearing that from his inner circle and then repeating those same claims over and over again was showing that he was repeating statements that he knew were false?
All right, so let's saying that this is actually happening and everybody's telling him this, that doesn't mean that he agrees with them, for one. And number two, we're talking about state of mind, and there were a lot of weird things going on with that election. We're talking about him knowingly lying, and I just...
Okay, so are we going to say that the president of the United States can be so, like, intellectually, mentally disabled that maybe he believes something that is standing in stark contrast to every single person around him and in his administration, and he can have a reasonable reason to believe that? That's Donald. He can literally be the only person that believes these things? Does that sound like a reasonable person to you?
Yeah, he can have his own beliefs and thoughts. Yeah, absolutely. He could hear all this from all these people and still look at everything and be like, no, it was stolen from me, and, and really believe it.
What would he have to hear to change his mind then? Or is he delusional at this point?
Well, I mean, maybe nothing. Maybe it is, but...
So he can be delusional. You're comfortable with a president that is actually delusional. You said nothing can change his mind. That's the definition of a delusion.
That's why I don't like this particular thing, because I don't really think that you could prove that he knowingly, like, oh, I definitely know I lie, that I lost the election, now I'm lying. Something recorded saying that, yes, I know I lost, or something written, something showing that, yes, he definitely saw and knew that he lost, admitted it, acknowledged it, and yet still went out and said this.
Okay, so...
I would say, then, yeah, you probably got him on lying. But other than that, like... Yeah,
okay, so then if Trump ends up pleading guilty then to any of these charges, you're going to say like, oh, okay, well, I guess he did?
Well, it's hard to argue against that if you plead guilty. However, I will say this, that when the government can get you to plead guilty to things you're not guilty of.
Okay, so a guilty plea wouldn't work. I'm guessing no confession then at this point would work. It would have to be a prior written... Well, because now you would just say it's part of a guilty plea, right?
It's times like this that remind me why I made the Bays video. Go watch it after this if you haven't already. Anyway, let's cover the delusional option first, as stupid as it is. Barr floated the idea during his own testimony, as he described Trump's increasingly more erratic and desperate attempts to cling on to any lifeline he could.
When I walked in, sat down, he went off on a monologue saying that there was now definitive evidence involving fraud through the Dominion machines, and a report had been prepared by a very reputable cybersecurity firm, which he identified as Allied Security Operations Group, and he held up the report, and then he asked that a copy of it be made for me. And while a copy was being made, he said, you know, this is absolute proof that the Dominion machines were rigged. The report means that I'm going to have a second term. And then he gave me a copy of the report. And as he talked more and more about it, I sat there flipping through the report and looking through it. And to be frank, it looked very amateurish to me. Didn't have the credentials of the people involved, but I didn't see any real qualifications. And the statements were made very conclusory, like, these machines were designed to, engage in fraud or something to that effect, but I didn't see any supporting information for it. And I was somewhat demoralized because I thought, boy, if he really believes this stuff, he has, lost contact with he's become detached from reality if he really believes this stuff.
Keep in mind that Barr was extremely loyal to Trump all throughout his presidency. When Barr said publicly to the Associated Press on December 11th that there was no evidence of widespread fraud, going directly against Trump's public messaging at the time, Trump got quite angry.
On December 1, 2020, Attorney General Barr said in an interview that the Department of Justice had not found evidence of widespread election fraud sufficient to change the outcome of the election. Ms. Hutchinson, how did the president react to hearing that news?
I first noticed there was ketchup dripping down the wall, and there's a shattered porcelain plate on the floor. The valet had articulated that the president was extremely angry at the Attorney General's AP interview and had thrown his lunch against the wall.
We're jumping ahead a bit now, but on the evening of January 6th, a White House employee recounted his casual encounter with Trump as he retired for the night.
6:27, the president left the dining room and he went up to the White House residence for the night. On the screen is the last photograph of the president that night as he went into the residence. As he was gathering his things in the dining room to leave, President Trump reflected on the day's events with a White House employee. This was the same employee who had met President Trump in the Oval Office after he returned from the ellipse. President Trump said nothing to the employee about the attack. He said only, quote, "Mike Pence let me down."
After January 6th, Eugene Scalia wanted to call a meeting of the cabinet, but Mark Meadows objected, with the reasoning that Trump was basically in a depressive state.
On the morning of the 7th, the decision I arrived at was that the most constructive thing I could think of was to seek a meeting of the cabinet. I thought that trying to work within the administration to steady the ship was likely to have greater value than simply resigning, after which point I would have been powerless to really affect things with the administration.
Gene thought that there should be a cabinet meeting.
Do you know why Mark thought it would not be?
I don't remember why. I think it probably had something to do with Mark's view of how the president might react and that, but things like that.
Now, there was a couple of the calls where, Meadows and or Pompeo, but more Meadows, how's the president doing? Like Pompeo might say, how's the president doing? And Meadows would say, well, he's in a really dark place. Like here's one, for example, on the 7th of January. So this is day after, right? POTUS is very emotional and in a bad place. Meadows.
And during the outtakes of Trump's official statement on that day, Trump still refused to say he had lost, with what appears to be a bitter or petulant attitude.
But this election is now over. Congress has certified the results. I don't want to say the election's over. I just want to say Congress has certified the results without saying the election's over, okay?
Thought Congress is certified. Now Congress is
Yeah, right.
Now Congress
I didn't say over, so let me see.
This tracks with Trump's sullen demeanor during his conversations with Pence directly after the election, as well as the stuff from the Peril book. This is all circumstantial evidence that Trump is, best case scenario, emotionally immature, which itself could be circumstantial evidence of some underlying mental problem. However, I also understand that circumstantial evidence of delusions is pretty weak. Probably the strongest thing I've been able to find is this hilarious claim.
So the final email here included a completely baseless conspiracy theory that an Italian defense contractor uploaded software to a satellite that switched votes from Trump to Biden. The Select Committee investigation found that this wild, baseless conspiracy theory made it from the recesses of the internet to the highest echelons of our government. On December 31st, Mr. Meadows received this internet conspiracy theory from Representative Perry. On the screen now is the text that Representative Perry sent to Mr. Meadows, copying a YouTube link with the message, quote, "Why can't we just work with the Italian government?" The next day, the president's chief of staff sent the YouTube link to Mr. Rosen, who forwarded it to Mr. Donahue. Mr. Donahue, did you watch this video?
I did, Congressman.
How long was the video?
Approximately 20 minutes.
Let's just take a look at an excerpt of that video, if we may.
What's being said out of Rome, out of Italy, is that this was done in the U.S. Embassy. That there was a certain State Department guy whose name I don't know yet. I guess this is probably going to come out in Italy at some point. And he was the mastermind, not the mastermind, but anyway, the guy running the operation of changing the votes. And that he was doing this in conjunction with some support from MI6, the CIA, and this Leonardo group.
Mr. Donahue, what was your reaction when you watched that entire 20-minute video?
I emailed the acting attorney general and I said pure insanity, which was my impression of the video, which was patently absurd.
We'll have more to say about Congressman Scott Perry in a future video, but I do love the idea that somebody is feeding schizo YouTube videos up the chain of command to Trump. This is actual meme magic shit. By the way, that link on screen is dead. I wanted to see it for myself. The channel was run by a guy named Brad Johnson, and it was nuked off of YouTube for multiple community guideline strikes, probably related to this very video. It is actually available to watch on the Internet Wayback Machine, and I know I said this was going to be autistically thorough, but guys, I'm not cutting clips of this thing into my video. I don't want my channel to get destroyed for re-uploading banned content. I will confirm though, the Johnson video is every bit as much the schizo post as you think it is, claiming that British and German spies conspired with Italian criminals within an Italian corporation to use a military satellite to beam false Biden votes into Dominion voting machines. It's fucking nuts. However, Mark Meadows, remember this is Trump's chief of staff, actually wanted Acting Attorney General Rosen to meet with this Brad Johnson YouTube guy and discuss the contents of the video, if you can fucking believe that.
Mr. Rosen, you were asked by Mr. Meadows to meet with Mr. Johnson, who is the person in that video. What was your reaction to that request?
So ordinarily I'd get an email like this and there was no phone call. It would just come over the transom. But this one he called me, Mr. Meadows, and asked me to meet with Mr. Johnson. And I told him this whole thing about Italy had been debunked and that should be the end of that, and I certainly wasn't going to meet with this person. And he initially seemed to accept that. He said, well, why won't you meet with him? I said, because if he has real evidence, which this video doesn't show, he can walk into an FBI field office anywhere in the United States. There's 55 of them. And he said, okay. But then he called me back a few minutes later and complained and said, I didn't tell you, but this fellow Johnson is working with Rudy Giuliani, and Mr. Giuliani is really offended that you think they have to go to a FBI field office. That's insulting. So couldn't you just have the FBI or you meet with these guys? And by then I was somewhat agitated and told him that there was no way on earth that I was going to do that. I wasn't going to meet with Mr. Johnson. I certainly wasn't going to meet with Mr. Giuliani. I'd made that clear repeatedly, and said that's the end of that. Don't raise this with me again. And so, because Mr. Donahue and I had been exchanging our views about this, I think it was 7:13 on a Friday night of New Year's Day. Had run out of patience, and I sent the email that you're talking about, where I made pretty clear that I had no interest in doing anything further with this.
Just to button this up, Mr. Donahue, did you receive a follow-up call from a Department of Defense official about this conspiracy?
I did. I believe it was that same day.
Can you give details on that at all?
I received a telephone call from Kash Patel, who I know was a DOD official at that time, worked for, I believe, Acting Secretary of Defense Miller, and he didn't know much about it. He basically said, do you know anything about this Italy thing and what this is all about? And I informed him that the Chief of Staff had raised the issue with us in his office on December 29th, that we had looked into it a little bit. We had run the name that was provided to us by the Chief of Staff. I learned that that individual was in custody in Italy. He had been arrested for a cyber offense of some sort in Italy. The allegation was that he had been exfiltrating data from his company. He was either an employee or a contractor of that company, and he was in custody. That the whole thing was very, very murky at best, and the video was absurd. But that we, the department, were not going to have anything to do with it, and DOD should make up its own mind as to what they're going to do. But I made it clear to him that I didn't think it was anything worth pursuing.
She called the video absurd, and despite the absurdity of that conspiracy theory, we learned that Mr. Meadows discussed it frequently in the White House. And Mr. Meadows didn't let the matter go. The request went from the Department of Justice to the Secretary of Defense, Christopher Miller. As you'll hear, Secretary Miller actually reached out to a high-ranking official based in Italy to follow up on this claim.
The ask for him was, can you call out the defense attaché Rome and find out what the heck's going on, because I'm getting all these weird, crazy reports, and probably the guy on the ground knows more than anything.
The Select Committee confirmed that a call was actually placed by Secretary Miller to the attaché in Italy to investigate the claim that Italian satellites were switching votes from Trump to Biden. This is one of the best examples of the lengths to which the President Trump would go to stay in power, scouring the internet to support his conspiracy theories shown here, as he told Mr. Donahue in that December 27th call, quote, "You guys may not be following the internet the way I do."
Yeah. So this story is, to me, the most plausible path forward for the claim that Trump genuinely disbelieved the counsel of everyone around him because he was off his rocker. Maybe Trump was so brain-rotted after 4 years of Twitter insanity that he actually began to believe that whatever went viral online was somehow actually true. All of us know all too well that social media addiction is worse for your mind than RFK's brainworms, and there's no reason Trump would be immune to it, especially considering his unique position. Let's explore the other option, the one that I personally believe is more plausible, that Trump just lied. He was told he lost, he knew he lost, and he repeated to everyone that he actually won because he was lying and he wanted to stay in power. I don't just mean times when Trump or Giuliani or whoever else was told one thing by somebody and then actively said the opposite thing later because they presumably didn't believe them. We've gone over tons of those already. No, this time I'm talking about statements from the Trump team that point towards them actually knowing they're doing something duplicitous. Chris Stirewalt, a former Fox News political editor who ran their 2020 election night poll analysis, testified to Congress under oath that it was normal to expect mail-in ballots to favor the Democrats, due to demographic differences between Democrats and Republicans, that this was not evidence of fraud, and that the Trump campaign explicitly knew this fact and conspired to use it to cast doubt on the election's validity.
In the 40 or 50 years, let's say, that Americans have increasingly chosen to vote by mail or early or absentee, Democrats prefer that method of voting more than Republicans do. So basically, in every election, Republicans win election day and Democrats win the early vote. And then you wait and start counting, and it depends on which ones you count first, but usually it's election day votes that get counted first. And you see the Republicans shoot ahead, and then the process of bailing and binding and unbinding all those mail-in votes. And some states like Pennsylvania refuse to count the votes first, so you have to wait for all of that to come in. So in every election, and certainly a national election, you expect to see the Republican with a lead, but it's not really a lead. When you put together a jigsaw puzzle, it doesn't matter which piece you put in first, it ends up with the same image. So for us, who cares? But that's because no candidate had ever tried to avail themselves of this quirk in the election counting system. We had gone to pains, and I'm proud of the pains we went to make sure that we were informing viewers that this was going to happen, because the Trump campaign and the president had made it clear that they were going to try to exploit this anomaly. And we knew it was going to be bigger because the percentage of early votes was higher, right? We went from about 45% of the votes being early and absentee to, because of the pandemic, that increased by about 50%. So we knew it would be longer, we knew it would be more. So we wanted to keep telling viewers, hey, look, the number that you see here is sort of irrelevant because it's only a small percentage of these votes.
So this red mirage, that's really what you expected to happen on election night.
Happens every time.
Steppen concurred with Stirewalt's analysis and informed Trump himself of this phenomenon.
I recounted back to that conversation with him, in which I said, just like I said in 2016 was going to be a long night. I told him in 2020 that it was going to be a process again, as the early returns are going to be positive, and we're going to be watching the returns of ballots as they rolled in thereafter.
So is it fair to say you're trying to present what you thought would be a realistic picture of what might happen over the course of that night, being election night?
That night and the days that followed. Yeah, I always told the president the truth, and I think he expected that from me, and I told him it was going to be a process. It was going to be, we're going to have to wait and see how this turned out. So I just like I did in 2016, I did the same thing in 2020.
Right out of the box on election night, the president claimed that there was major fraud underway. I mean, this happened, as far as I could tell, before there was actually any potential of looking at evidence. And it seemed to be based on the dynamic that at the end of the evening, a lot of Democratic votes came in, which changed the vote counts in certain states. And that seemed to be the basis for this broad claim that there was major fraud. And I didn't think much of that because people had been talking for weeks, and everyone understood for weeks that that was going to be what happened on election night.
Despite Trump knowing about this, Trump publicly said stop the vote anyway.
We want all voting to stop. We don't want them to find any ballots at 4 o'clock in the morning and add them to the list.
This is because Trump had a premeditated plan where if he had an early lead and began to lose it due to mail-in ballots, he would simply declare victory anyway and claim that everything after his lead was fraudulent. He told this plan to 2 unnamed campaign workers, but he also told it to Mark Short, Pence's chief of staff, if you recall. Steve Bannon also knew of this plan. He's person of interest 1 here in this court document, and he described it to a group of Trump supporters like this. What Trump is going to do is just declare victory. That doesn't mean he's the winner. He's just going to say he's the winner. He has a natural disadvantage with mail-in ballots, and Trump's going to take advantage of it. That is our strategy. He's going to declare himself the winner. Giuliani, who's co-conspirator 1 here, recommended the same course of action to Trump. When Michael Rosen, a Trump staffer, was told by election officials a batch of votes heavily in Biden's favor is right, he responded, "Find a reason it isn't. Give me options to file litigation, even if it is right." The election official said he would cause a riot, and Rosen responded, "Make them riot, do it." Hirschman, who's P9 here, told Trump directly that Giuliani was unable to prove his claims in a courtroom, and Trump simply responded, "The details don't matter." Nick Luna, Trump's director of Oval Office operations, P15 here, overheard Trump tell family members, "It doesn't matter if you win or lose the election, you have to fight like hell." Trump's actions as president also show that he lost, despite his claims to the contrary. Testimony from Alyssa Farah, the White House communications director, to Congress under oath, as well as from Hutchinson and General Milley, revealed that Trump privately said he lost the election.
I remember maybe a week after the election was called, I popped into the Oval just to give the president the headlines and see how he was doing. And he was looking at the TV and he said, "Can you believe I lost to this effing guy?"
Mark raised it with me on the 18th. And so following that conversation, we're the motorcade ride driving back to the White House. And I had said, does the president really think that he lost? And he said, a lot of times he'll tell me that he lost, but he wants to keep fighting it. And he thinks that there might be enough to overturn the election, but he pretty much has acknowledged that he's lost.
So we're in the Oval and there's a discussion going on. And the president says, I think it could have been Pompeo, but he says words to the effect of, "Yeah, we lost. We need to let that issue go to the next guy," meaning President Biden.
On November 11th, 2020, Trump rushed out the orders to withdraw from both Afghanistan and Somalia against the advice of all of his military council, knowing that it would be a monumental shit show that Biden would have to deal with.
Knowing that he had lost and that he had only weeks left in office, President Trump rushed to complete his unfinished business. One key example is this. President Trump issued an order for large-scale U.S. troop withdrawals. He disregarded concerns about the consequences for fragile governments on the front lines of the fight against ISIS and al-Qaeda terrorists. Knowing he was leaving office, he acted immediately and signed this order on November 11th, which would have required the immediate withdrawal of troops from Somalia and Afghanistan, all to be complete before the Biden inauguration on January 20th. As you watch these clips, recall that General Keith Kellogg was the National Security Advisor to the Vice President and had served as Chief of Staff to the National Security Council for President Trump. And General Milley was the chairman of the Joint Chiefs of Staff at the Pentagon.
Are you familiar with a memo that the president reportedly signed on November 11th, 2020, ordering that troops be withdrawn from Afghanistan and Somalia?
Yes.
So I think you might have seen some things where there's a memo or something from Johnny McEntee to Douglas McGregor. It says, here's your task to get U.S. forces out of Somalia, get U.S. forces out of Afghanistan.
When you first interviewed and met Colonel Douglas McGregor, is it fair to say you discussed this decision of withdrawing from Somalia and Afghanistan, correct?
Yeah, I'm sure that was part of it, yeah.
And that was the position that he was taking over there was senior advisor to the Secretary of Defense, is that correct?
Yes.
So on that same day, just so I'm clear, he responded back to you that they, meaning DOD leadership, was not going to take any of those steps without an order.
Without a directive, yeah.
I explained in language that should be in the order while I was in the meeting with McEntee, and this was my answer to him. I said, if you want this to happen, or the president wants this to happen, he's got to write an order.
So you never wrote this down in any capacity?
Well, I sketched on a piece of paper for him some key statements. The president directs. This is, what's the right word? Boilerplate language?
Who within his office drafted the order?
It was myself and one of my assistants.
McEntee duly types it up, brings it in to the president. The president signs it, and boom, it's over, faxed over, or emailed, scanned over to Chesebro, delivers it to me.
Was it by auto pen, or was it the president himself signing it?
It was the president.
And who obtained that signature?
I did.
It is odd. It is non-standard. It is potentially dangerous. I personally thought it was militarily not feasible, nor wise.
And I proceeded to tell the PPO and proceeded to tell McGregor that if I ever saw anything like that, I would do something physical, because I thought what that was done was a tremendous disservice to the nation. And by the way, that was a very, very contested issue. There were people who did not agree with getting out of Afghanistan. I appreciate their concerns. An immediate departure, that memo said, would have been catastrophic. It's the same thing what President Biden went through. It would have been a debacle.
Keep in mind, the order was for an immediate withdrawal. It would have been catastrophic, and yet President Trump signed the order. These are the highly consequential actions of a president who knows his term will shortly end.
Deputy Attorney General Donahue testified that Trump simply wanted the Department of Justice to say that the election was corrupt and leave the rest to him, implying that he wanted the optics of legitimacy and not an actual investigation.
You also noted that Mr. Rosen said to Mr. Trump, quote, DOJ can't and won't snap its fingers and change the outcome of the election. How did the president respond to that, sir?
He responded very quickly and said, essentially, that's not what I'm asking you to do. What I'm just asking you to do is just say it was corrupt and leave the rest to me and the Republican congressman.
So let's now put up the notes where you quote the president. As you're speaking to that, he said, the president said, just say the election was corrupt and leave the rest to me and the Republican congressman. So, Mr. Donahue, that's a direct quote from President Trump, correct?
That's an exact quote from the president, yes.
The next note shows that even that the president kept pressing. Even though he'd been told that there was no evidence of fraud, the president keeps saying that the department was, quote, obligated to tell people that this was an illegal, corrupt election.
That's also an exact quote from the president, yes.
Let me just be clear. Did the department find any evidence to conclude that there was anything illegal or corrupt about the 2020 election?
There were isolated instances of fraud. None of them came close to calling into question the outcome of the election in any individual state.
And how would you describe the president's demeanor during that call?
He was more agitated than he was on December 15th. The president, throughout all of these meetings and telephone conversations, was adamant that he had won and that we were not doing our job. But it did escalate over time until ultimately the meeting on January 3rd, which was sort of the most extreme of the meetings and conversations.
And Hutchinson directly witnessed Trump admit to Mark Meadows that he lost and he wanted to cover it up.
On December 11th, Trump's allies lost a lawsuit in the U.S. Supreme Court that he regarded as his last chance at success in the courts. A newly obtained Secret Service message from that day shows how angry President Trump was about the outcome. Quote, just FYI, POTUS is pissed. Breaking news, Supreme Court denied his lawsuit. He is livid now.
This is the day that the Supreme Court had rejected that case. Mr. Meadows and I were in the White House residence at a Christmas reception. And as we were walking back from the Christmas reception that evening, the president was walking out of the Oval Office, so we crossed paths in the Rose Garden colonnade. The president was fired up about the Supreme Court decision. And so I was standing next to Mr. Meadows, but I stepped back, so I was probably 2-3 feet catty corner from him, diagonal from him. The president's just raging about the decision and how it's wrong and why didn't we make more calls, and just his typical anger outburst at this decision. And the president said he had said something to the effect of, I don't want people to know we lost, Mark. This is embarrassing. Figure it out. We need to figure it out. I don't want people to know that we lost.
Ever since Trump left office, he has continued to insist that he actually won, but he finally slipped up and admitted the truth in public a few weeks ago on Lex Friedman's show.
And I became president. Then the second time I got millions more votes than I got the first time. So I was told if I got 63 million, which is what I got the first time, you would win. You can't not win. And I got millions of more votes than that and lost by a whisker.
There's no adherence to any sort of principle or standard in Trump's conduct here, only the naked pursuit of more power. So, where does this leave us? If Trump actually truly believes in his heart of hearts that he won 2020 and everyone around him was lying or wrong or corrupt or whatever, then he's unfit for the presidency solely due to the fact that his brain doesn't function anymore. And this story kind of just ends there. However, I personally believe that Trump knew, and he consistently lied, slipping up only a few times, because he's only human, and even well-practiced liars eventually make a couple of mistakes, after having to maintain the same story for years on end. The next question is, how do we know that the Eastman scheme was actually put into motion? Is there evidence he actually tried to pull this off, or was it just an on-paper plan? Well, evidence beyond what I've been displaying on screen this whole video. That stuff has been from court filings, testimony to Congress under oath, and video clips of the people involved. But we do have more than that. We have the physical dueling elector papers. We have the legitimate electors, signed and sealed by the state governors in the National Archives. And we have the false electors, created by individuals within the Republican Party who were sympathetic to the Eastman scheme. Republican Party staffers went to the Capitol building on January 6th and unsuccessfully tried to deliver these sets of electors to Mike Pence. The 7 states in question are Arizona, Georgia, Michigan, Nevada, Pennsylvania, Wisconsin, and New Mexico. Let's go over them. Arizona law states, after the Secretary of State issues the statewide canvass containing the results of a presidential election, the presidential electors of this state shall cast their Electoral College votes for the candidate for president and the candidate for vice president who jointly received the highest number of votes in this state as prescribed in the canvass. Here's a comparison of the real and fake elector papers. The fakes lack the state seal, the governor's signature, and they falsely claim to have been legitimately representing Arizona's state government when they were not. Georgia law states, the presidential electors chosen shall assemble at the seat of government of this state at noon of the day directed by the Congress of the United States, and shall then and there perform the duties required of them by the Constitution and laws of the United States. Just like with Arizona, the Georgia electors lack the governor's signature, and falsely claim to legitimately represent the state. In fact, they look almost identical to their Arizona counterparts. Michigan law states, the electors for president shall convene in the Senate chamber at the capital of this state at 2 p.m. EST, on the first Tuesday after the second Wednesday in December, following the electors' election. Like the previous two, the fake Michigan electors lack the governor's signature and the state coat of arms, and falsely claim to legitimately represent the state. And once again, they appear to be from the same uniform template. A video from Michigan showing this process in action actually made the rounds back in December of 2020, where false electors unsuccessfully tried to enter the state capitol building and be counted. They were turned away at the door by state police, who confirmed they were not on the list of legitimate electors.
What did he say? He said we can't enter.
What I said was, for the Capitol Commission, for the governor's office, for the Speaker of the House, for the Speaker of the Senate, the Capitol is closed unless you have an office here to conduct business today, or if you are taking part in the Electoral College process. Anybody else is not permitted to come in.
They are here for electors. They're take part in the electoral process.
Yeah, the electors are already here. They've been checked in.
They're also electors.
Capitol is closed. All 16 electors that we've been advised by the governor's staff that we're going to be here to vote in the Electoral College have been checked in. They're already here.
But these are the rest of the electors.
I understand. But the Capitol is closed. Everybody's permitted to come forward.
Captain, the electors are also, the GOP electors are also on the governor's certificate of ascertainment.
I'm not going to get into a political debate. I'm following orders.
It's not a political debate.
Okay.
It's the official sealed document. The certificate of ascertainment has also the GOP electors. They are here. They're trying to do their constitutional duty.
I understand.
And their constitutional duty requires them to be at the Senate chamber today at 2 p.m. Okay. They're here.
All right, they're not, I understand they're not being permitted in. If you have a problem, you can contact the governor's office, the Speaker of the House, the Senate Majority Leader, or
I saw the governor's press release this morning. It said due to COVID. Is that the reason being given?
No.
All right, that was what the press release said. Is there another reason why?
You'd have to ask the governor's office to answer that question. I don't have.
We have a copy of paperwork that was prepared as electors under their constitutional duty. Can I speak to the Sergeant of Arms of the Senate to deliver it to the chamber today?
He's in a meeting right now at the Electoral College. He's not available to meet.
Captain Green, is it Captain?
First Lieutenant Green.
First Lieutenant, can you deliver this?
I cannot.
Okay. Is there anyone here that's willing to allow us, I've got elected officials and electors, to deliver this to the Senate today at 2 p.m.
Okay. I can ask the Senate Majority Leader, the House Majority Leader, and
Senator Mike Shirkey, would you deliver that to him? Tell him Ian Northen.
You can contact his office directly and make arrangements to drop that off to him, sir. I'm not going to take anything.
You're not letting us in the building. His office is inside.
He's not here.
What's that?
He's not here.
So are you telling me that the Senate chamber is in session and the Senate leader's not here?
Yeah. So you'd have to contact his office and make arrangements to meet with him to turn over.
Right. Somebody from the governor's team that's running this.
You'd have to contact the governor's office with their team to make arrangements for them.
All right. Again, the electors by statute, it's statute MCL 168.47, have to be at the Senate chamber today.
Okay.
At 2 p.m. They're trying.
I'm telling you that they're not going to be allowed to enter the Capitol, sir.
All right. Thank you, Lieutenant.
You're welcome. Thank you.
What was your hope and plan today by coming here?
The electors can speak for themselves, but the hope and plan is for them to follow their constitutional duty. Under the U.S. Constitution, not just the Michigan Constitution, but under the U.S. Constitution, the electors have a duty to vote for their chosen candidate. In this case, the GOP electors slate their chosen candidate, President Trump. The Democrat electors are inside, I'm told, slating their chosen candidate, Joseph Biden.
Nevada law states, the Secretary of State shall preside at the meeting of the presidential electors. The nominees for presidential elector whose candidates for president and vice president receive the highest number of votes in this state at the general election are the presidential electors. I'm sure at this point you understand the song and dance. No state seal, no governor's signature, false claim, same template. To add insult to injury, the Secretary of State of Nevada clearly did not preside over the meeting of the false electors, which is legally required to legitimize them, as per the text of the law. Pennsylvania law states, the electors chosen, as aforesaid, shall assemble at the seat of government of this Commonwealth, at noon of the day directed by the Congress of the United States, and shall then and there perform the duties enjoined upon them by the Constitution and laws of the United States. I couldn't find a direct comparison shot of the Pennsylvania electors, unlike the previous ones, but there does exist this high-quality, long-range photo of the legitimate Pennsylvania elector papers in a staffer's hand in the Senate chamber. The fake Pennsylvania electors are available online as a PDF. And you guessed it, it's exactly the same as the others. Wisconsin law states, the electors for president and vice president shall meet at the state capitol following the presidential election at noon the first Monday after the second Wednesday in December. And would you look at that? The fake electors look a little bit different this time. They put the seal of the Republican Party of Wisconsin at the top. But yes, all the same problems. And finally, New Mexico law states, the presidential elector shall be nominated by the state convention according to the rules of that party on file with the Secretary of State. Upon the nomination of presidential electors, the chair and secretary of the convention shall certify the names and addresses of the nominees not less than 63 days prior to the election to the Secretary of State. The Secretary of State shall record the nominees' names in the Secretary's office as the presidential elector nominees of that party. And yes, all the same problems. Though, like Pennsylvania's, these also weren't included in the collage presented to Congress. There's a reason for that, by the way, why only some of the fake papers were presented to Congress. Let's get into it. In total, 84 people signed their names to these fake electors across the 7 states, and 4 of those states have gone ahead with charges against these individuals for falsifying electoral certificates. In Arizona, charges have been filed against not only the 11 electors for their part in the scheme, but 7 Trump aides as well, including Rudy Giuliani and Mark Meadows. One of the fake Arizona electors has already pled guilty to filing a false instrument. That felony charge I mentioned earlier regarding knowingly putting false information on important documents and attempting to file them with the government. In Georgia, 3 of the 16 fake electors have been indicted, and 8 have agreed to immunity deals. The lieutenant governor of Georgia, Burt Jones, who was a state senator back in 2020, is facing a special investigation by a state prosecutor for his involvement in the scheme. In Nevada, the case was dismissed due to filing it in the wrong jurisdiction. That was a couple of months ago. It'll probably be refiled properly in the near future. In Michigan, a trial is currently ongoing, including witness testimony from one of the electors who entered into a plea deal. Michigan law states that prosecutors must prove beyond a reasonable doubt that the fake electors knew they were breaking the law by filing these false documents. And the one witness they've got has already testified they didn't know what they were doing was illegal. They were simply told by Republican higher-ups that the party has their back. One of the 15 false electors is Mashawn Maddock, a local politician active in the Michigan Republican Party, as well as a member of that Women for Trump group that put on the Save America rally on January 6th. CNN obtained a secret audio recording of Maddock at a low-level Republican event, where she boasted about her and her husband's involvement in the Eastman scheme at the request of the Trump campaign.
We fought for investigations into every part of the election we could. He fought for a team of people to come and testify in front of the committee. We fought to seat the electors. The Trump campaign asked us to do that. I'm under a lot of scrutiny for that today. And my husband has, he's suffered for that a little bit in Lansing because it's not very popular.
And though this isn't really part of today's topic, I don't really know when I'm ever going to talk about this woman again, so fuck it. By 2022, she was the co-chair of the Michigan Republican Party, and she was the one who made the whole litter boxes in schools for kids who self-ID as trans furries thing go viral. Yeah, that was her. You know, at this point, I'm just not surprised that legitimate lawsuits and fraud is mixing with the dumbest memes and viral happenings on the internet. The remaining states, New Mexico, Pennsylvania, and Wisconsin, are all states that Congress didn't focus on during its investigation of January 6th, and there's a reason for that. These fake electors added a clause to their paperwork that didn't exist in the other states, declaring that the elector papers are only valid and should only be counted if a court ruling or a declaration by that state's legislature legitimized them, as a result of the various Trump legal actions and recount attempts being successful. For example, compare Pennsylvania's false elector papers to, say, Michigan's. They look identical, they clearly came from the same template, but notice this extra bit at the beginning in the Pennsylvania papers? That clause probably saved their hides, frankly. All the rest of them face legal trouble, and when interviewed by Congress, they were quite open about how sold up the river they all felt by the Republican establishment.
We were just, kind of useful idiots or rubes at that point. A strong part of me really feels that it's just kind of as the road continued and as that was failure, that got formulated as what do we have on the table? Let's just do it.
And now, after what we've told you today about the Select Committee's investigation, about the conclusion of the professional lawyers on the campaign staff, Justin Clark, Matt Morgan, and Josh Finley, about their unwillingness to participate in the convening of these electors, how does that contribute to your understanding of these issues?
I'm angry. I'm angry because I think in a sense, no one really cared if people were potentially putting themselves in jeopardy.
Would you have not wanted to participate in this any further as well?
I absolutely would not have. Had I known that the three main lawyers for the campaign that I'd spoken to in the past and were leading up were not on board. Yeah.
I was told that these would only count if a court ruled in our favor. So that would have been using our electors, it would have been using our electors in ways that we weren't told about, and we wouldn't have supported.
He told me that the Michigan Republican electors were planning to meet in the Capitol and hide overnight so that they could fulfill the role of casting their vote per law in the Michigan chambers. And I told him in no uncertain terms that that was insane and inappropriate.
In one state, the fake electors even asked for a promise that the campaign would pay their legal fees if they got sued or charged with a crime.
The trials for some of these false electors are still ongoing, and they've largely been forgotten about by Trump, his campaign, and the Republican Party, having served their purpose. So at this point, we've now seen the plan to steal the election through the use of false electors. We've seen Trump's direct, purposeful involvement in the plan. We've seen that the plan was, in fact, illegal. And we've seen evidence that the plan was actually attempted and not just theorized. What is Trump's defense for these actions, do you think? What does he have to say for himself? Well, of the various court cases currently pending against Trump, United States of America versus Donald Trump in the District of Columbia is specifically about the false elector scheme. There's nothing in this one about Stormy Daniels and grab him by the pussy. There's nothing in here about Mar-a-Lago or classified documents. Nothing in here about Putin or Russia or whatever. This case is specifically about the plot to create false electors and the pressuring of Mike Pence to toss out legitimate electors and install Trump as president. Do you think Trump disputed any of the facts of the case as presented in the indictment? Any of the physical evidence? Or any of the testimony describing his behavior? No, he let that all stand. Did he make the claim that the evidence presented was somehow obtained illicitly and therefore should be disqualified? A claim that others have made, and I'll talk about a little bit later in the video. Nope, he didn't say that either. Did he say he had nothing to do with the scheme? It was all Eastman and Chesebro and Giuliani and whoever else, and he's just not involved. Again, no. Trump didn't deny any of it. Trump had his lawyer, Dean John Sauer, make the case to the D.C. Circuit Court of Appeals that as president, he's simply immune from all prosecution.
Constitution in the Article 2 sectional investing clause, as interpreted very clearly by Chief Justice Marshall Marbury against Madison, says Article 3 courts lack jurisdiction to engage in examination of the president's official acts.
He didn't contest the factual accuracy of anything I've laid out here today. The plots, the memos, the false electors, the transcripts of his communications with Mike Pence or with John Eastman or anyone else, all the moves to see him installed as president, regardless of the outcome of the vote. Oh no, Trump did all of that. He simply said that he should be allowed to do it, because at the time, he was the president. This is the Nixon immunity claim all over again.
Well, when the president does it, that means that it is not illegal. By definition. Exactly.
The Supreme Court eventually returned with Trump versus United States 2024, where the court declared that presidential immunity from criminal prosecution presumptively extends to all of the president's official acts, with absolute, unchallengeable immunity for official acts within an exclusive presidential authority that Congress can't regulate. The sections of the executive branch which are exclusively the president's and outside the bounds of Congress are the presidential pardon, the command of the military, the enforcement of laws through the Department of Justice, and some of the control functions of the executive, like the appointment of some positions, though not all of them. Any actions that a president takes concerning these domains, he is absolutely immune from prosecution. That's a little bit spooky to me. But Trump versus United States 2024 also declared that a president's communications have presumptive immunity. But that immunity and other immunities for actions taken outside of the core parts of the office can be pierced if the government shows that applying a criminal prohibition on the president's behaviors would pose no dangers of intrusion on the authority and functioning of the executive. The court also stated that all personal actions a president took were not protected by presidential immunity, even if he is president at the time. The court did not actually declare Trump absolutely immune to everything, which is what Trump asked for, and also which a lot of his followers irrationally screamed they won on Twitter, since people really only read headlines. Nor did they decide whether or not Trump was immune from prosecution for his actions during the Eastman scheme. They simply laid out the standard by which to determine immunity, and then kicked it back to the lower court to apply that standard and make the decision. Though Justice Barrett did give her opinion that the president has no authority over state legislatures or their leadership, so it's hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. In other words, Justice Barrett, despite being appointed by Trump, seems to believe that at least for some of Trump's actions during the Eastman scheme, presidential immunity doesn't apply. Which makes sense, because acting on behalf of candidate Donald Trump is not the same thing as President Donald Trump. This case is still ongoing, with the prosecution recently having filed additional paperwork updating their claims to be compatible with Trump versus United States 2024's immunity standards, and outlining large swaths of conduct they claim is not covered by immunity. But putting aside the legality of it, on a moral level, surely it was not the intention of the founders of the United States, who wrote the Constitution and designed the process and set into place the Electoral College, that a valid path to re-election is to use the powers of the office of the presidency to contribute to a scheme where false electors are created, not ratified by the states, and used as tools to discard true electors in order to install a president who didn't actually win the election. By the way, Giuliani gave a similar defense when he was eventually hauled in front of a court. He couldn't claim presidential immunity, obviously, but he did admit that everything he said during these events was a lie. However, lying is free speech, so everything should be protected by the First Amendment. I mean, alright, fair enough. But what about all those actions you did that were justified by those lies, Rudy? The next question on that list of common objections from right-leaning people is, alright, we've got the plot, we've got Trump's involvement, we've got evidence that was actually put into motion, we've got Trump accepting the factual accuracy of it all, but all of this stuff, the testimonies, the video clips, the false elector papers, the memos, the public statements, was it all legitimately obtained? Where did it all come from? Well, the majority of the evidence used in the DC court case against Trump was unearthed by Congress's January 6th committee, formerly known as the United States House Select Committee to investigate the January 6th attack on the United States Capitol. This committee was presented with physical evidence. It heard witness testimony under oath and subpoenaed documents, emails, texts, tweets, everything related to the Capitol riot on January 6th, the claims of 2020 election fraud, and Trump's implementation of the Eastman scheme in his attempt to hold on to power. The committee interviewed over 1,000 witnesses, reviewed over 1 million documents, and published an 850-page report of its findings, almost all of which is publicly available to read for yourself if you want. The committee took 1.5 years to go through everything from July 2021 to January 2023, and at the end of it all, it recommended to the Department of Justice that Trump and Eastman be prosecuted for their behavior. This is the reason it took until early to mid-2023 for the array of charges to finally be filed against Trump. It took Congress just that long to go through all this shit.
Ours is not a system of justice where foot soldiers go to jail and the masterminds and ringleaders get a free pass. Mr. Chairman, as you know, our committee had the opportunity last spring to present much of our evidence to a federal judge, something that distinguishes our investigation from any other congressional investigation I can recall. In the context of resolving evidentiary privilege issues related to the crime-fraud doctrine in the Eastman case, U.S. District Court Judge David Carter examined just a small subset of our evidence to determine whether it showed the likely commission of a federal offense. The judge concluded that both former President Donald Trump and John Eastman likely violated 2 federal criminal statutes. This is the starting point for our analysis today. The first criminal statute we invoke for referral, therefore, is Title 18, Section 1512C, which makes it unlawful for anyone to corruptly obstruct, influence, or impede any official proceeding of the United States government. We believe that the evidence described by my colleagues today and assembled throughout our hearings warrants a criminal referral of former President Donald J. Trump, John Eastman, and others for violations of this statute. The whole purpose and obvious effect of Trump's scheme were to obstruct, influence, and impede this official proceeding, the central moment for the lawful transfer of power, in the United States. Second, we believe that there is more than sufficient evidence to refer former President Donald J. Trump, John Eastman, and others for violating Title 18, Section 371. This statute makes it a crime to conspire to defraud the United States. In other words, to make an agreement to impair, obstruct, or defeat the lawful functions of the United States government by deceitful or dishonest means. Former President Trump did not engage in a plan to defraud the United States acting alone. He entered into agreements, formal and informal, with several other individuals who assisted him with his criminal objectives. Our report describes in detail the actions of numerous co-conspirators who agreed with and participated in Trump's plan to impair, obstruct, and defeat the certification of President Biden's electoral victory.
Funnily enough, Trump once actually blustered that he wanted to testify to the January 6th committee, and when the committee took him up on the offer, he sued them to ensure he wouldn't have to go. As a general rule, Republicans seem to consider everything that was discovered by the January 6th committee to be illegitimate. Every time I've debated a Trump supporter on this topic, they always reject all of its findings, all of its evidence and testimony, because the committee is apparently biased against Trump, and so nothing in it can be trusted. Let's examine that allegation more closely. Congressional committees are official bodies tasked with investigating a specific event, getting all information about the event on public record, and then recommending a portion of the government take action on the information uncovered, whether that's passing a law or prosecuting a crime. The committees have the same subpoena powers as the court, and refusing to testify when summoned carries a legal penalty. Some committees are permanent, continuing in perpetuity to deal with ongoing problems, and some are temporary, disbanding after the task is completed and the recommendations made. All temporary committees and all permanent committees at the end of a House session are required by law to submit at least one copy of their findings to the National Archives. A high-profile modern example of a temporary congressional committee was the House Select Committee on Benghazi in 2012, which was created to investigate the 2012 attack on an American compound in Libya. The Benghazi Committee is most notable for unearthing evidence leading to the Hillary Clinton email server scandal. After the Benghazi Committee completed its purpose, it was disbanded and its findings handed over to the National Archives, the same as every other high-profile committee out there, like the committee investigating 9/11, or Watergate, or the assassination of President Kennedy, or the attack on Pearl Harbor. They all operate this way. Committees are formed by a vote in the House, though there are also Senate committees as well. Committees manned by both the House and the Senate are called commissions. There's no hard and fast rule for who gets to sit on a committee, but as outlined by the Congressional Research Service, by custom and precedent, the party with a majority in the House leads the committee. The minority recommends appointments to the majority and gets to fill about 2/3 of the seats that the majority does. So if a committee has 9 majority members, it'll have 6 minority members. If it's got 7 majority, it'll have 5 minority, that sort of thing. All committee members have the authority to request a witness be subpoenaed, and the request is granted if 1/3 of the committee agrees. This allows the minority to subpoena witnesses without the majority's consent, if necessary. The January 6th committee was unique in that it featured 7 Democrats and only 2 Republicans. Those 2 Republicans were Liz Cheney and Adam Kinzinger, 2 anti-Trump Republicans. This is the reason that most Trump supporters reject everything that was documented by the committee. Their guys never had the chance to question the witnesses or call their own, after all. And you know what? Fair enough. However, we can dig a little bit further than that. The Democrats did, in fact, adhere to precedent and law. The Republicans were given the opportunity to appoint 5 House reps to the January 6th committee. The Republican House leader at the time, Kevin McCarthy, put forward Jim Banks, Jim Jordan, Rodney Davis, Kelly Armstrong, and Troy Nehls. Nancy Pelosi, the Democrat House leader, rejected Jim Jordan and Jim Banks, and told McCarthy to pick 2 other guys. She accepted Davis, Armstrong, and Nehls. McCarthy refused. He insisted that either all 5 of his guys were accepted, or he would walk out and appoint nobody.
Speaker Pelosi has taken the unprecedented step of denying the minority party's picks for the Select Committee on January 6th. It's an egregious abuse of power. Made it undeniable this panel has lost all legitimacy and credibility. And it shows exactly what I warned back at the beginning of January, that Pelosi would play politics with this. Unless Speaker Pelosi reverses course and seats all 5 Republicans, we will not participate. We will run our own investigation.
The other Republicans in the House fell in line. None of them would accept an appointment by Pelosi, with the exception of Cheney and Kinzinger. As a result, those 2 were censored by the Republican Party for their betrayal. The Republican Party line was that anyone complying with the January 6th committee investigation was hurting Republican prospects in the 2022 midterms, and therefore they were traitors. So the Republicans did actually have a chance to question the witnesses and call their own, but it's McCarthy who walked away from the table. This isn't the fault of the Democrats. The obvious Republican counterpoint is that it's because Pelosi rejected 2 of McCarthy's appointments, a move that is unheard of in the modern history of congressional committees. And you know what? Fair enough, that's true. So why did she do it? Well, Trump supporters once again believe it's because Jordan and Banks are die-hard Trump loyalists, and Pelosi wanted the committee to be biased against Trump. That is one possibility, but once again, we can dig a little bit further than that. It turns out that Jordan and Banks were 2 of the many people of interest that the January 6th committee wanted to investigate. They had both been involved in the Supreme Court case Texas versus Pennsylvania, which attempted to invalidate the Electoral College votes of 4 states. And that case was one of the many cases the committee was tasked with looking into. Additionally, it was publicly revealed during the committee that Jordan texted Mark Meadows information about the Eastman scheme on January 5th. He was also a part of the attempt to deliver the false electors to Pence on January 6th. But most importantly of all, Jim Jordan was one of a group of Republican congressmen who met with Trump privately on December 21st, an event described by Marjorie Taylor Greene on Fox News.
On December 21st, some Republican members of Congress met with President Trump in the White House to talk about overturning the 2020 election. Let's hear Representative Marjorie Taylor Greene talk about how this meeting got set up.
I was the only new member at the meeting. I called President Trump on Saturday and said, we've got to have a meeting. There's many of us that feel like this election has been stolen.
So on the screen, you'll see that President Trump's Chief of Staff, Mark Meadows, tweeted about that meeting right after it happened. He said, quote, "Several members of Congress just finished a meeting in the Oval Office with President Donald Trump, preparing to fight back against mounting evidence of voter fraud. Stay tuned."
The official White House visitor logs show that 10 House reps were in attendance. They were Brian Babin, Andy Biggs, Matt Gaetz, Louis Gohmert, there he is, Paul Gosar, he's the guy who offered the Arizona objection on January 6th with Ted Cruz, Andy Harris, Jody Heiss, Jim Jordan, the main man, Scott Perry, we've heard his name before too, and Marjorie Taylor Greene. Hutchinson confirmed in her testimony that several other members were, quote, dialed in over the course of that meeting, including Jim Banks. Also present were Trump, Meadows, Giuliani, and Eastman, but not Cipollone, the official White House legal counsel, who was prevented from attending. After the January 6th committee began to investigate the contents of this meeting, Mark Meadows stopped cooperating with the committee's requests for information, and, like Trump, filed lawsuits to prevent him from testifying. Though the official transcript of what was said in that December 21st meeting has not been made public, as far as I can tell, we do have some limited information. On the day of, Politico interviewed Congressman Mo Brooks, who also attended the meeting by phone. Brooks stated the meeting was planning and strategy for January 6th, because the group of House reps believed that the election had been stolen. The committee also obtained an email from Brooks to Meadows setting the meeting up.
President's private schedule for December 21st, 2020 shows a private meeting with Republican members of Congress. We know that Vice President Pence, Chief of Staff Mark Meadows, and Rudy Giuliani also attended that meeting. We obtained an email that was sent from Congressman Mo Brooks of Alabama to Mark Meadows setting up that meeting. The subject line is White House meeting December 21st regarding January 6th. In his email, Congressman Brooks explained that he had not asked anyone to join him in the, quote, January 6th effort, because in his view, quote, only citizens can exert the necessary influence on senators and congressmen to join this fight against massive voter fraud and election theft.
After the meeting, Heiss tweeted out, "I will lead an objection to Georgia's electors on January 6th. The courts have refused to hear the president's legal case. We're going to make sure the people can." A few days after the meeting, Gohmert filed that lawsuit from before that was dismissed, that Trump blasted Pence as being too honest, and people are going to hate you for not supporting. That suit, Gohmert versus Pence, asked the Supreme Court to declare that the vice president did in fact have the unilateral power to reject electors as per the Eastman scheme. Now, most of the House reps who attended the December 21st meeting seem to have all been acting under the mistaken but ultimately good faith belief that Trump actually won the 2020 election, and the Democrats were trying to steal it from him. Many of them gave public statements, both before and after the meeting, to that effect.
So there's widespread evidence of fraud because people haven't done their jobs. Durham and Barr will deserve a big notation in history when it's written of the rise and fall of the United States if they don't clean up this mess, clean up the fraud, Do your jobs and save this little experiment in self-government.
Again, I join my colleagues in calling on Attorney General Barr to immediately let us know what he's doing.
We're already working on challenging the certified electors. And then what about the courts? How pathetic are the courts?
January 6th, I'm joining with the fighters in the Congress, and we are going to object to electors from states that didn't run clean elections. Democracy is left undefended if we accept the result of a stolen election without fighting with every bit of vigor we can muster.
The ultimate date of significance is January 6th. This is how the process works. The ultimate arbiter here, the ultimate check and balance is the United States Congress. And when something is done in an unconstitutional fashion, which happened in several of these states, we have a duty to step forward and have this debate and have this vote on the 6th of January.
Today is the day American patriots start taking down names and kicking ass.
And unlike with Trump, Giuliani, and Eastman, there's no deluge of testimony or evidence showing that they're lying when they say this stuff. That being said, let me remind you of Donahue's testimony from earlier.
What I'm just asking you to do is just say it was corrupt and leave the rest to me and the Republican congressman.
So, Mr. Donahue, that's a direct quote from President Trump, correct?
That's an exact quote from the president, yes.
The next note shows that even that the president kept pressing. Even though he'd been told that there was no evidence of fraud, the president keeps saying that the department was, quote, obligated to tell people that this was an illegal, corrupt election.
When Trump said, just declare it corrupt and leave it to me and the Republican congressman, you have an obligation to tell people it was corrupt. He's referring to the House reps who attended the December 21st meeting. They may have legitimately believed the election was stolen, but this was Trump attempting to set up the appearance of fraud so that those House reps could use it in their objection on January 6th, in much the same way that Trump was pushing Raffensperger to set up the appearance of fraud in that phone call. However, there is at least a little bit of evidence that some of the December 21st attendees knew what they were doing was illegal, or at least they became aware it was illegal after January 6th. Just like members of Trump's staff, a bunch of them also scrambled to request presidential pardons as it became clear that Trump's presidency was actually winding down.
5 days after the attack on the Capitol, Representative Mo Brooks sent the email on the screen now. As you see, he emailed the White House, quote, pursuant to a request from Matt Gaetz, requesting a pardon for Representative Gaetz, himself, and unnamed others. Witnesses told the Select Committee that the president considered offering pardons to a wide range of individuals connected to the president. Let's listen to some of that testimony.
And was Representative Gaetz requesting a pardon?
Believe so. The general tone was, we may get prosecuted because we were defensive of, the president's positions on these things. The pardon that he was requesting, was as broad as you could describe. From the beginning, I remember he's from the beginning of time up until today, for any and all things. I think he mentioned Nixon, and I said Nixon's pardon was never nearly that broad.
Are you aware of any conversations or communications regarding the possibility of giving Congressman Matt Gaetz a pardon?
I know he had asked for it, but I don't know if he ever received one or what happened with it.
How do you know that Congressman Gaetz asked for a pardon?
He told me.
Tell us about that.
He told me he'd asked Meadows for a pardon.
Were you involved in or did you witness any conversations about the possibility of a blanket pardon for everyone involved in January 6th?
I had heard that mentioned, yeah.
Do you know whether the president had any conversations about potentially pardoning any family members?
I know he had hinted at a blanket pardon for the January 6th thing for anybody, but I think he had for all the staff and everyone involved, not with January 6th, but just before he left office, I know he had talked about that.
After all of this came out in the committee, the normally charismatic and well-spoken Jim Jordan was rather vague and hesitant about his involvement in the whole affair in subsequent interviews. When this evidence came out, Jordan was rather vague about his involvement in subsequent interviews.
Speak with the former president on January 6th. Did you talk to the former president before, during, or after the attack on the Capitol?
Of course I've talked to the president.
All three?
Of course I've talked to the president. I've been clear about that. I talk to him all the time. Of course I talked to the president. I talked to him that day. I've been clear about that. I don't recall the number of times.
Was it before, during, or after the attack on the Capitol?
I talked to the president after the attack.
So not before or during?
Right.
Okay, and
I've been clear about that.
But he hasn't been clear about that at all. Jordan seems just as flustered to answer that question now as he was in July when he said he'd look into it.
Did you talk to the former president that day?
I've talked to the former president umpteen times, thousands, I mean not thousands
on
times,
January
but
6th.
countless times. I talk to the president. I never talk about what we talk about because I just don't think that's appropriate, just like I don't talk about what happens in Republican conferences. So I've talked to the president numerous times. I continue to talk to the president since he's left office.
on January 6th, Congressman.
Yes, I've talked to the president. I've talked to the president so many, I can't remember all the days I've talked to him, but I've certainly talked to the president.
A day later, after having some time to consider it, this is what happened when Jordan was asked again.
Did you speak with President Trump on January 6th?
Yeah, I mean, I spoke with the president last week. I speak with the president all the time. I spoke with him on January 6th. I mean, I talk with President Trump all the time, and that's I don't think that's unusual. I would expect members of Congress to talk with the president of the United States when they're trying to get done the things they told the voters in their district to do. I'm actually kind of amazed sometimes that people keep asking this. But of course, I talk to the president all the time. I talked to him, like I said, I talked to him last week.
On January 6th, did you speak with him before, during, or after the Capitol was attacked?
I'd have to go. I spoke with him that day after. I think after. I don't know if I spoke with him in the morning or not. I just don't know. I'd have to go back and. I mean, I don't know that when those conversations happened. But what I know is I spoke with him all the time.
And a month later, after having even more time to consider his answer, the infamous "I don't recall" made an appearance twice. Quote, "Look, I definitely spoke to the president that day. I don't recall. I know it was more than once. I just don't recall the times."
It is plainly inappropriate for Banks, and especially Jordan, to sit on an investigatory body that is also looking into their own actions. If it were simply that Nancy Pelosi wanted the committee to be biased against Trump, as Trump supporters claim, then Pelosi would have also rejected Troy Nehls, who is himself an outspoken and devout Trump loyalist. But she didn't, because he wasn't being investigated by the committee. This leaves two questions, one asked by each side of the argument. The Trump supporter asks, if we're expected to believe that Jordan and Banks were rejected from sitting on the January 6th committee because they were under investigation by it, why did Pelosi not make that reasoning public when she rejected them? Their assumed answer, by the way, is because it was actually done for partisan reasons, to purge the Trump supporters from the committee. And to their credit, I went back and listened to all of Pelosi's interviews on this topic during that time. And they're right. Pelosi was actually very vague and non-committal about her reasoning for rejecting them until it came out in open session that they were persons of interest.
So as the legislation allows, I did not accept 2 of the 5 people were appointed. They have made statements and taken actions that I think would impact the integrity of the commission, of the committee, the work of the committee. Right from the start, when the members acted in that way and said they were not going to vote for the certification that Joe Biden was president, I said to the members, do not let that stand in the way of you finding bipartisan agreement on legislation here. The 2 people that I excluded, so 3 of the 3 that I appointed, one of them voted against the ratification, and the other 2 voted for it. Having said that, though, the other 2 made statements and took actions that just made it ridiculous to put them on such a committee seeking the truth.
Can you elaborate more specifically what statements and what actions caused you to?
Well, no, I won't. I'll just give you their statements. You'll give you their statements. I think one of them was sort of of Mr. Banks was that the Biden administration was responsible for January 6th. There was no Biden administration on January 6th. But let's not go into that. Are you up to date on their statements? I'd like you to see them because they completely just make it impossible for them to exercise judgment. Again, this is about seeking the truth. And it's about not, as I said in my comment, with respect for the integrity of the investigation, with concern that the American people want to know the truth, and in light of statements and actions taken by them, I could not appoint them. I said that while this may be unprecedented, so was an attack on the Capitol. I'm not going to spend any more time talking about them.
Meanwhile, the Democrat asks, why would McCarthy walk away rather than simply appoint 2 more people? Troy Nehls is proof that Pelosi is actually accepting Trump supporters on the committee, and there's no shortage of them in the Republican Party, so why not pick 2 more? Their assumed answer is, McCarthy intentionally tanked the January 6th committee by not lending it his party's legitimacy. He chose people he knew were under investigation, knowing Pelosi would have to reject them, giving him a plausible out, as well as an excuse for the Republicans to later reject the findings of the committee wholesale due to its supposed bias. We currently don't have a definitive answer to either of these questions, and we probably won't get one unless somebody's private communiques leak or something. But on a personal level, this is just my opinion, it's actually quite plausible that Nancy Pelosi, being a lifelong House member who intimately knows the slimy, cutthroaty game of backroom politics, discovered through the grapevine that Jordan and Banks were obviously going to get fingered. Their actions leading up to January 6th weren't exactly private. So even though evidence had not yet officially been entered into the record, Pelosi acted appropriately by removing them from consideration. Additionally, to me, it's way less likely that McCarthy walked away from the committee over a genuine slight to the honor of the Republican Party, or that he truly believed Pelosi was refusing Trump supporters for partisan reasons. Because once again, Troy Nehls made the cut. My more right-wing friends often tell me to start recognizing patterns, and well, you can kind of see one here. How does that old saying go? If you don't know what a plot is meant to achieve, see who benefits from it? The goal of discrediting the January 6th committee, and all of its findings, which are, by the way, completely legitimate, is served very well by McCarthy walking away, and is a great way for Jim Jordan to escape scrutiny. Setting aside these questions, though, here's the real issue. None of this stuff means that the findings of the committee are actually illegitimate. This discussion, while interesting for sure, does not mean the physical evidence was faked, or all the videos were AI generated, or every single person who testified, all 1,000 of them, were blatantly lying to Congress's face, and it's only the wit and intuition of Jordan and Banks that could have possibly discovered the con job. If the Republican Party had more questions that they wanted asked, or they had their own evidence they wanted to present, well, the cold hard truth is, they had their chance, and they threw it away for partisan reasons. I've even seen some Trump supporters use a highly bastardized version of the fruit of the poisonous tree logic, claiming that regardless of whose fault it is for the bias, or regardless of how truthful the findings are, it all must be tossed out, forgetting the fact that the fruit of the poisonous tree is a law metaphor used to describe evidence that is obtained illegally by the police, and the fact that McCarthy walked does not actually make the committee or its evidence illegal. This is such a fucking dumb idea that I guarantee you Trump supporters would not accept it if we flip the script. Imagine, for example, the Benghazi Committee in 2012, only this time it was the Democrats who refused to play ball. None of them sat on the committee, they punished any Democrat dissenters who went as independents, and then a couple of years down the road, they all collectively used the claim of bias to disregard anything that came out against Hillary Clinton. That would be both immoral and retarded, just like it is here. There's also another January 6th committee claim I should probably go over too real quick, since it's just a small one. When the Republicans retook the House in 2022, they've been pushing the narrative that the January 6th committee destroyed its evidence to prevent the new Republican majority from investigating the event themselves. I've seen this get reposted on social media tons of times. Trump has even repeated it himself, and each time the amount of evidence apparently destroyed by the Democrats only continues to increase. It went from one file to a bunch of files to videos to transcripts to the entirety of the findings, despite, the publicly available 850-page document with associated evidence in the archives. Here's what actually happened. Do you recall earlier when I mentioned that committees close up shop when they finish their duties and hand everything over to the archives? Well, everything went over there, including text transcripts of all video interviews. And all of this stuff was provided to Trump directly as a part of the discovery process of his trial, even though he continuously claims that evidence has been destroyed. Nonetheless, Republicans have pushed, and they continue to push, the idea that Democrats have destroyed everything as the committee wound down its operations out of spite towards Trump and the incoming Republicans, even though it's standard practice to hand over all material to the archives, not to the incoming Congress. So, like it or not, I don't think there's any legitimate reason for rejecting the January 6th committee's findings. The best argument against the Democrats here is that due to the actions of the Republicans, there were no Trump supporters on the committee, which subsequently robbed the investigation of an explicitly pro-Trump perspective. And yeah, okay, I get it. But you know what? There's only so much sympathy I can muster for people who shoot themselves in the foot and then complain it hurts. Oh, by the way, remember when McCarthy walked away from the committee and he said that when Republicans retake the House, they'll investigate the event on their own?
We will run our own investigation.
Well, a second Republican-led January 6th committee has so far failed to materialize. What we did get, though, was the Committee on the Weaponization of the Federal Government, tasked with searching for evidence that the Biden administration is weaponizing the Department of Justice against their political opponents. This committee is headed up by none other than Jim Jordan. Unlike the Republicans last time, the Democrats didn't walk away. They fully chaired their section of the committee, and as a result, they've had the opportunity to call and question witnesses themselves. This committee's work is still underway, but its findings so far have been rather lackluster. We won't spend too much time on this since it is a detour of a detour, but Jordan claimed he found dozens of whistleblowers alleging abuses by the government. However, only 3 of them have been willing to provide private anonymous testimony before the committee was even formed.
There have been a lot of mention of information and testimony that you all have received from whistleblowers. When are you planning on providing that to the minority?
You could have been for the very first deposition, or excuse me, transcribed interview of the whistleblower. I was there when he testified on Tuesday.
Okay, that's fine. I assume you'll turn those over. But what about, you talk about dozens of whistleblowers. When are we going to get that information?
When they testify, when we work with, I'll work with the ranking member on that information.
You don't have any transcriptions of their interviews?
We have the first one, and we have the dozens who've come and talked to our office.
They talk to your office privately?
They talk to Republican staff, right.
And they're not transcribed, no notes, no nothing?
The first one happened Tuesday.
No, I'm not talking about the first one.
The first one happened Tuesday, the next one happens tomorrow, the third one happens next Wednesday, and we'll continue to do that.
You just said dozens. Do you have notes from those, or they're just talking to you, your staff?
Mr. Chairman, isn't that how whistleblowers typically work?
Well, it's how they're supposed to work. It's not how they worked in the impeachment that Mr. Goldman was a part of when Mr. Schiff said he didn't have contact with that whistleblower, but in fact
actually
he did.
it worked exactly appropriately until Mr. Trump would not allow.
We're doing it the way we're supposed to do it, Mr. Goldman.
No, you're supposed to turn it over to the minority.
When they come and testify, you'll have access to the transcript like everyone on the committee will.
You mean your staff is not going to turn it over to our staff? We're just in the dark?
No, when the transcript is done, you will get the transcript.
I mean of the dozens of whistleblowers you have already talked to that came to talk to your staff.
Yeah, what do you want me to turn over there?
Did you?
Their names?
Notes? Anyone take notes?
I'll be happy to talk with the ranking member on how we handle that information.
Thank you.
All I'm telling you is we will schedule each for a deposition, and we are doing that. You didn't show up for the first one, but you could have been there. With that,
I didn't know about it.
The chair now recognizes. The chair now.
Cicilline was there.
There were Democrat members at the
I think you need to work on your schedule.
Upon examination of their testimony, it became obvious that none of them had any first-hand knowledge of any law being violated. 2 of the 3 men admitted in their testimony they had been paid by Kash Patel, a former National Security Council member during Trump's presidency and a die-hard Trump supporter.
Chair recognizes the gentleman from New York, Mr. Goldman.
Thank you, Mr. Chairman. I'm going to move quickly through a couple different questions. We established earlier credibility matters, certainly for witnesses who appear before us. Mr. Boyle, do you know who Kash Patel is?
I do.
Have you received any money from Kash Patel or his organization?
I have.
When you previously met with the majority members and or majority staff of this committee, was Kash Patel present for that meeting?
No.
To your knowledge, has Kash Patel ever spoken to the committee members on your behalf?
Not that I know of.
Mr. Friend, what about you? Do you know Kash Patel as well?
Yes.
And did you receive any money from Kash Patel?
Yes, he gave me a donation last November.
A donation?
Yes.
Are you a charitable organization?
I was an unpaid, indefinitely suspended man trying to feed his family, and he reached out to me and said he wanted to give me a donation.
Mr. Friend and Mr. O'Boyle, I don't have much time, but you agree that you were field agents, correct?
Correct.
And you understand chain of command, do you not, Mr. O'Boyle?
I do.
Right. So that if you make a suggestion to a supervisor and your supervisor overrules you, that's the nature of the business, isn't it?
Not if it's a violation of a law.
And you make decisions about whether grand jury subpoenas should be served or not as a field agent of the FBI?
The gentleman is
expired. If I have a reasonable belief, I can make a protected disclosure, which is what I've done.
Okay, but do you think you make those decisions?
The gentleman is expired. Gentleman yields back. Chair recognizes himself. Mr. O'Boyle, why do you think they came down on you so darn hard?
The Democrats have requested the other whistleblowers be called to testify. However, their identities are private, and Jordan, so far, has refused to reveal them. Now, to the Republicans' credit, it's not like the entire thing is a gong show. For example, 2 of the Twitter Files guys testified and brought forward legitimate concerns about the government's involvement with big tech, which I will cover in a future video. But for the most part, the Committee on the Weaponization of the Federal Government has been a big fat nothing burger. And in some ways, it actually appears to itself be an attempt to weaponize the government, however inept it might be. Here's my question regarding this whole thing. If these guys really were worried about the supposed missing videos from the January 6th committee, like if they went back and read the text transcripts and said, you know what, this witness they interviewed, there's something weird about this, what's missing here? Okay, fair enough. Simply subpoena them again, bring them back in, and ask them all the questions you want. That solves the whole problem. But personally, I'm not sure Republicans want the problem solved. If they did, if they were so sure that everything was rigged and all it took was a good, honest investigation by solid, moral, forthright Republicans, then they wouldn't be dicking around with all this other nonsense. They'd be actively doing what McCarthy claimed they didn't get a chance to do with the January 6th committee. We're running down the list of common right-wing objections pretty steadily at this point. We've got the Eastman scheme laid out beforehand, we've got people working to implement it up to January 6th, we've got physical evidence and video and testimony and communications and all the rest of it, we've got Trump's court case where he doesn't deny any facts of the matter, he simply believes as president he should have been allowed to try and steal the election. And we've got a legitimate congressional investigation, unearthing, archiving, and verifying all of this stuff as real and true. The next question Trump supporters put forward is, why would any of this stuff be illegal anyway? Haven't there been dueling electors before? And the answer to that question is yes, of course. There's been all sorts of weird election shenaniganery over the years, but those examples are different than 2020, and I can show you exactly how. A commonly cited comparison is the 1960 presidential election, Nixon versus Kennedy. Nixon was the Republican candidate and also the VP to Eisenhower. Kennedy was the young Democrat upstart. In Hawaii, the official tally showed that Nixon won by 140 votes. Governor James Colonna certified the Republican electors. However, there were clear discrepancies in the count, and Democrats successfully petitioned the Hawaiian court for a recount. The court challenge was still ongoing by December 19th, the day the electors were legally required to formally pledge themselves for Nixon. Nonetheless, Democratic electors also convened on that day and drew up alternate elector papers, pledging themselves for Kennedy. So far, this sounds pretty similar to Eastman's scheme. However, the recount completed before Christmas, and the new total showed that Kennedy had actually won by 115 votes, flipping him the state. As a result, the Hawaiian court ruled on December 30th that Hawaii's 3 Electoral College votes should go to Kennedy, and not Nixon as initially pledged. A letter to Congress, again certified by Governor Colonna, was rushed out by airmail explaining the situation. According to the official congressional record of January 6, 1961, 2 sets of electors were presented to Vice President Nixon, including dated and sealed letters explaining the situation. Plus, it's 1961. International phone calls exist at this point, even if a bit primitive, so it's not like people didn't know what was going on. As per the Electoral Count Act, dueling electors had to be debated by the House and the Senate, but such a debate could only be triggered by a congressman and a senator objecting in writing. Nixon said, in order to not further delay the counting of the vote, and without the intent of establishing a precedent, the chair suggests that the electors named in the January 4th, 1961 certificate be considered as the lawful electors. If there is no objection, the chair instructs the tellers to count the electors for John F. Kennedy and Lyndon B. Johnson. The record states there was no objection. But keep in mind that Nixon did not assert any unilateral authority here, and that the option to object was still available, it was simply not utilized. So yes, there were dueling electors in 1960, but the difference is, Hawaii's state government had ratified the alternate set of electors by January 6, 1961, making them the legitimate electors. None of the 7 states where Trump launched legal campaigns had ratified the alternate set of electors by January 6, 2021, making them illegitimate. Well, okay, what about the 1800 election? Thomas Jefferson versus John Adams. America's first real political rivalry. Libertarianism versus social democracy. Locke versus Rousseau. Jefferson was the VP presiding over the count this time, and in the lead-up to January 6, 2021, people online began to cite 1800 as precedent that the vice president can simply discard any electors he wants at a whim. The theory's prevalence on the internet is due to the Twitter account Rasmussen Reports, who quoted an analysis of 1800 by saying, Jefferson, among the most revered founding fathers of our country, only became president because he used his unilateral power as president of the Senate to open and count the presidential ballots in his own favor. He also quoted Stalin, those who vote decide nothing, those who count decide everything. Let's just ignore that part. Giuliani leaned on this logic during his Save America rally speech.
Given the questionable constitutionality of the Election Counting Act of 1887, that the vice president can cast it aside, and he can do what a president called Jefferson did when he was vice president. He can decide on the validity of these crooked ballots, or he can send it back to the legislatures.
And Eastman repeatedly referred to the 1800 election in his memos, stating that Jefferson established the precedent of the VP having the unilateral power to accept or reject electors at his pleasure. Eastman's claim that the Electoral Count Act is unconstitutional is partially because of his view that it violated this precedent from Jefferson. This claim about the 1800 election is based on a 2004 law article, which was analyzing the 2000 election, specifically Al Gore's own dual role as presidential candidate on the one hand, and on the other, the current VP counting Electoral College votes for his victorious opponent, George Bush. The 2004 law article compared the situation to the similar Jefferson one, but noticed something odd about it. In the 1800 election, Georgia's 4 electoral ballots appeared to be irregular. The House and Senate tellers, who were appointed to open and record the ballot's contents, acknowledged the irregularity in their notes, but Jefferson himself did not. He simply entered the votes into the record. The authors of that 2004 article were stunned to learn that historians had failed to recognize Jefferson's blatant power grab, and wondered if Al Gore should have followed in his footsteps by ignoring the clerks and simply using his VP authority to accept or toss electoral votes as he felt like. Trump supporters dug up this article 16 years later and latched onto it for dear life, endlessly repeating its juicy theories. But they all apparently failed to actually read the article all the way through, because at the end, the supposed irregularity is revealed. The Georgia ballots were in a different format than the other 15 states. There were 16 states in 1800, by the way. Here's an Electoral College ballot from Virginia from 1789. Yeah, it's not 1800, but the format remained the same until the printing press began to be used for these things. The ballot recites Electoral College processes, presents the tally of the vote. George Washington got 10 votes here. And at the bottom, you can see signatures with personal seals in the form of these faded stamps, acting as certification. To compare, here's Georgia's Electoral College ballot from 1800. It's a small slip of paper with the names of the candidates, Jefferson and Burr, and the 4 elector names underneath each. But that's it. It looks kind of weird, like it's incomplete. However, also saved in the National Archives are the envelopes the ballots arrived in, and it's on the envelopes from Georgia where we find the seals and signatures and declaration that these are the legitimate electors as ratified by the state government. The so-called irregularity recorded by the 1800 tellers was the fact that part of the ballot's meaningful content was written on the envelope and not just the sheet of paper, which is why Jefferson simply counted the votes. They were the correct votes. Georgia's congressional delegation offered no objection to Jefferson's actions. Adams, his opponent, a well-regarded writer and attorney, made no public or private complaint that we know of. Georgian state records also show that Jefferson solidly won the vote. This was not a power grab by Jefferson. It did not establish that the VP can arbitrarily choose votes on a whim. Considering that this story is the central pillar supporting the entire Eastman scheme pushed by Eastman and Chesebro and Giuliani, and the fact that it's not true, this means the entire plan had no actual legal foundation. Most damningly of all, Eastman himself admitted in private that Jefferson didn't actually do what he claimed he did. It was all made up.
The committee has shown footage of Mr. Eastman on the stage on the 6th, claiming that Jefferson supported his position, and a historical example of Jefferson. In fact, he conceded in that meeting Jefferson did not at all support his position, that in the election of 1800, there had been some small technical defect with the certificate in Georgia. It was absolutely undisputed that Jefferson had won Georgia. Jefferson did not assert that he had any authority to reject electors. He did not assert that he had any authority to resolve any issue during the course of that. And so he acknowledged by the end that there was no historical practice whatsoever that supported his position. He had initially tried to push examples of Jefferson and Adams. He ultimately acknowledged they did not work. As we've covered, he acknowledged it would lose 9-0 in the Supreme Court.
The final election that I see Trump supporters cite as precedent is 1876, the Democrat Tilden versus the Republican Hayes. Tilden won the popular vote, but neither man had an Electoral College majority. They needed 185 at the time. Tilden had 184, and Hayes had 165. Both men's campaigns claimed the 20 remaining contested electoral votes, 4 from Florida, 8 from Louisiana, 7 from South Carolina, and 1 from Oregon. Tilden only needed 1 to win, and Hayes needed all 20. It's important to note that this election took place a decade after the end of the Civil War. Some southern states were still under military occupation by the North. Both campaigns accused the other of stuffing ballot boxes, altering ballots, and intimidating voters, especially Democrat suppression of the black vote in the South. In Oregon, the story was pretty simple. One of the 3 electors chosen was actually a federal postmaster, and the Constitution forbids anybody who holds a federal post from also being a state's elector. Though Oregon went entirely for the Republicans, Governor Grover, a Democrat, replaced the Republican postmaster with a Democrat partisan who openly declared for Tilden in defiance of the state's vote. In the 3 southern states, Republican state officials invalidated their elections on the grounds of fraud and voter intimidation. Democratic violence against black voters was widespread, and the Democrats printed ballots with Abraham Lincoln's picture on them, a well-known Republican figure. Just to clarify, voting back then involved signing your name to either a Republican or Democrat slip of paper, and then dropping it into the ballot box. The Democrats put Honest Abe at the top of their slip, despite him being a Republican, with the hopes of fooling illiterate black voters into casting their vote improperly. As a result of the actions of the Republican-controlled state governments, Democrats in the South quickly created makeshift alternate governments in these 3 states, who themselves ratified 3 alternate sets of electors. This was a constitutional crisis for the United States, as the Constitution declared that the Vice President counts the votes, but did not say anything about who made the decision regarding dueling electors. As recorded in the history book on the era, Reunion and Reaction, Hayes supporters claimed that the authority lay squarely with the Vice President, based on the 12th Amendment's description of the VP's role as the counter of the ballots. Tilden supporters claimed that the House of Representatives should decide, also per the 12th Amendment's fallback for when nobody has a clear majority of ballots. Others proposed that the Supreme Court should step in. Things began to heat up. Probably the craziest claim comes from the article Public Opinion in the 1876 Election Compromise, where Kentucky Congressman Henry Watterson stated, "I expect to see here on the day the vote is to be counted, 100,000 unarmed citizens exercising in person the free man's right of petition, and giving the honest Republicans of both houses of Congress 2 guarantees. One, that the people only want what is right, the other, that they will accept nothing that is wrong." This claim morphed over the years, reprinted repeatedly across history, until finally landing on Wikipedia in the far more sensationalistic form of Watterson declared that an army of 100,000 men was prepared to march on Washington unless Tilden was declared president, which is a pretty big stretch from the original claim. However, this article is interesting for another reason, more closely related to our main topic today. When asked what he meant by this, Watterson responded, "The presidential vote shall be counted precisely as it always has been, and not by the President of the Senate, who has no power whatever except to open the certificates." By the way, the President of the Senate is the Vice President, unless he's incapacitated. Then it's the oldest member of the Senate. Some Republicans back in 1876 made the exact same claim that Eastman made in 2020, that the power to open and count the ballots as per the 12th Amendment allowed for the unilateral rejection of ballots. In 1876, though, there actually was those aforementioned legitimate issues with the election. However, even with those real issues, most lawmakers of the day still disagreed with this interpretation of the Constitution. In response to the crisis, Congress passed the Electoral Commission Act. Among other things, the act provided for the creation of the Electoral Commission to settle exactly this type of crisis. The commission was a 15-man body, 5 chosen by the House, 5 chosen by the Senate, and 5 court judges. The commission was empowered to determine whichever set of dueling electors was correct, and its decision could only be overturned by both houses of Congress. To cut a long story short, because there's a ton of deep lore on this one, the commission returned with a Hayes victory, deciding to uphold many of the Republican objections to Democrat voter intimidation and fraud. This decision was further vindicated 2 years later, when the New York Tribune published a series of private telegrams, where it was revealed that Democrat operatives attempted to bribe election officials. The telegrams were coded, and the main reason the scheme failed is because the parties involved used the wrong cipher, and were unable to decode the message authorizing the purchase of votes in time. The elections of 1880 and 1884 were also close, but not nearly this dramatic. Nonetheless, Congress was motivated to build on the Electoral Commission Act by passing the Electoral Count Act to solve all of these problems, the very same piece of legislation that Eastman thought was unconstitutional in 2020. Just to make sure I'm absolutely clear here, the legitimate irregularities of the 1876 election caused a constitutional crisis for the United States, one which Congress was charged with resolving. They did so not by asserting that the counter of the Electoral College votes had the unilateral authority to discard ballots as he saw fit. Instead, they passed the Electoral Count Act. And Trump's plan, the Eastman scheme, was to pretend that false irregularities during the 2020 election caused a similar constitutional crisis, and that the Electoral Count Act, the very same mechanism designed to resolve the crisis, was invalid. So, yes, there have been dueling electors before, but their existence does not mean that Trump's dueling electors are legitimate. Comparing Trump's actions in 2020 to 1800, 1876, or 1960 just does not make sense. Just because Hawaii in 1960 had dueling electors doesn't make Trump's dueling electors legal. A recount flipped Hawaii from Nixon to Kennedy in 1960. No such recount legitimized Trump's 7 sets of electors. And just because 1876 had voter fraud doesn't make Trump's claims of voter fraud valid. The Electoral Commission found widespread voter fraud and disqualified enough votes to flip the 1876 election. No investigation, audit, court case, state government, federal body, Electoral Commission, or anything else found any equivalent evidence for Trump in 2020. And Pence didn't actually have the authority to unilaterally reject legitimate electors in favor of the fake ones, because it turns out that Jefferson's actions in 1800 didn't actually establish that precedent either. It's entirely within Trump's rights to request recounts and audits and appeal to the court, but none of these efforts came back with a Trump victory. And despite L after L after L, Trump kept pushing the fake electors scheme anyway, past the counting and recounting of votes, past the meetings of the electoral colleges in the states, and the safe harbor deadlines in December, all the way up to the day of January 6th, with no legal or moral authority, with no precedent, and with no support from anyone in his own government. However, there's still the elephant in the room. Whenever I've debated a Trump supporter on this topic, if they actually stick around long enough to get down to this point, where everything has been laid bare and is undeniable, usually they rage quit the discussion well before this point. But if they don't, they fall back on this final claim. Even if Trump really did endorse the Eastman scheme, and even if he actively tried to implement it himself, and even if all the evidence and testimony and videos are real, and even if attacking the January 6th committee as the source makes no sense, and even if Trump himself admitted to the court that the facts of the case are true and he simply wants presidential immunity as his defense, and even if the other historical precedents don't apply, all of this stuff is justified by the fact that the election was stolen from Trump. This is probably the most common objection of all, that the Eastman scheme and everything that stemmed from it was, in reality and not simply in Trump's imagination, a last-ditch attempt to truly restore democracy after the Democrats and the deep state had stolen the election. And that everyone and everything truly was corrupt, with the exception of Trump himself, and the handful of sycophants who agreed with him. This is also false. However, the evidence for this claim will take more time than every other part of this video combined, so I'm not covering it today. The 2020 election was legitimate, and the next video will be about showing how it was legitimate. But nonetheless, even if true, even if Trump was stolen from, I find the argument unconvincing, and here's why. The proper place to dispute an election is the courts, not by subverting the electoral process after the courts have found no basis in your appeal. Trump filed his cases, he was told no, and he's been coping about it for 4 years. Yeah, I know, we'll go over the cases next time as a part of it as well. Some Republicans at this point might say, well, Trump still had some ongoing cases by January 6th. He just wanted to delay the certification to let them play out. In fact, Trump and Giuliani both said exactly this during their Save America speeches.
He can send it back to the legislatures, give them 5 to 10 days to finally finish the work.
All Vice President Pence has to do is send it back to the states to recertify.
However, there's nothing in law that actually allows for any of this. The law makes it explicitly illegal to do this, in fact. It's called obstructing an official proceeding, which is one of the charges that Trump and his co-conspirators have been slapped with. Lucky for us, they were dumb enough to lay out their intent in public speeches. Trump's claim that Pence can send the votes back to the states for recertification, that also isn't in the law. What is in the law is what happened in 1960, where the state government certified an alternate set of electors on their own without needing anything sent back by the VP. So why didn't that happen in 2020? Oh, it's because no state government actually wanted to recertify anything. Trump claimed repeatedly in public that the state governments wanted additional time to ratify alternate electors. But in actuality, no state made that request.
We now have letters from 5 legislatures begging us to do that. They're asking us. Georgia, Pennsylvania, Arizona, Wisconsin, and one other coming in.
States want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. They want it back.
In fact, every time Trump or his team asked, the state governments explicitly said they had no interest in ratifying any alternate electors. Their electors were legitimate and set in stone.
Why wouldn't you want to find the right answer, Brad, instead of keep saying that the numbers are right? So look, can you get together tomorrow? And Brad, we just want the truth. It's simple. And everyone's going to look very good if the truth comes out. It's okay. It takes a little while, but let the truth come out. And the real truth is I won by 400,000 votes, at least. So what are we going to do here, folks? I only need 11,000 votes. Fellas, I need 11,000 votes. Give me a break.
We didn't have any votes to find. We had to continue to look. We investigated, like I just shared the numbers with you. There were no votes to find. That was an accurate count that had been certified. And as our general counsel said, there was no shredding of ballots.
You're the Speaker of the Arizona House and a self-described conservative Republican. You campaigned for President Trump and with him during the 2020 election. Is it fair to say that you wanted Donald Trump to win a second term in office?
Yes, sir. Thank you.
And is it your understanding that President Biden was the winner of the popular vote in Arizona in 2020?
Yes, sir.
He then references a conversation in November 2020 in which he claims that you told him that the election was rigged and that he had won Arizona. To quote the former president, during the conversation, he told me the election was rigged and that I won Arizona, unquote. Did you have such a conversation with the president?
I did have a conversation with the president. That certainly isn't it, but there were parts of it that are true, but there are parts that are not, sir.
And the part that I read you, is that false?
Anywhere, anyone, anytime has said that I said the election was rigged, that would not be true.
And when the former president in his statement today claimed that you told him that he won Arizona, is that also false?
That is also false.
Additionally, you also don't get to ask for just a few more weeks while your final court cases play out either. Those cases ended in failure too, by the way, but it doesn't actually matter. January 6th is the cutoff, period. Again, some Republicans at this point might ask, so does that mean you can cheat, and as long as you get to the cutoff, you get away with it? Intuitively, that's actually a very compelling argument. That doesn't sound or feel fair to me. However, if you think about it for more than 5 seconds, yes, that's exactly how it is, and it has to be that way. It can't be any other way but that. You need to have a cutoff date by which a decision is made and adhered to, regardless of any evidence that comes out months or years later. Without one, there's no reason not to simply challenge the legitimacy of every single sitting president for his entire term, whether you have evidence or not, in the hopes that something sticks to the wall, and the Supreme Court, or whoever, reverses time and retroactively installs your guy as president. It's not a perfect solution. Far from it, in fact. But yes, out of necessity, if you actually do steal an election and then make it across the finish line, you've won. And I don't like that, but it is better than the alternatives. Think back to 2000, Bush versus Gore. Bush ended up becoming president after a bunch of controversial recount drama. And while Gore disagreed with the court's decision in that case, he respected it, and he backed down at the cutoff time.
Other disputes have dragged on for weeks before reaching resolution. And each time, both the victor and the vanquished have accepted the result peacefully and in a spirit of reconciliation. So let it be with us. I know that many of my supporters are disappointed. I am too. But our disappointment must be overcome by our love of country. And I say to our fellow members of the world community, let no one see this contest as a sign of American weakness. The strength of American democracy is shown most clearly through the difficulties it can overcome. While we yet hold and do not yield our opposing beliefs, there is a higher duty than the one we owe to political party. This is America, and we put country before party. We will stand together behind our new president. Let there be no doubt, while I strongly disagree with the court's decision, I accept it. I accept the finality of this outcome, which will be ratified next Monday in the Electoral College. And tonight, for the sake of our unity as a people and the strength of our democracy, I offer my concession. I also accept my responsibility, which I will discharge unconditionally, to honor the new president-elect and do everything possible to help him bring Americans together in fulfillment of the great vision that our Declaration of Independence defines and that our Constitution affirms and defends.
Man, compare Gore's attitude with Trump's continued public insistence that he actually won, and that the non-existent fraud is so bad that the Constitution should be put aside to remedy him. Al Gore really did set the standard for concessions after a contentious election. He presided over Electoral College objections to his own loss too, just like Pence. Check out how he handled his own January 6th.
For what purpose does the gentlewoman from California, Ms. Waters, arise?
Mr. Vice President, I rise to object to the fraudulent 25 Florida electoral votes.
Is the objection in writing and signed by a member of the House and a senator?
The objection is in writing, and I don't care that it is not signed by a member of the Senate.
The chair will advise that the rules do care, and the signature of the senator.
Mr. President, I am objecting to the idea that votes in Florida were not counted, and it's a sad day in America, Mr. President, when we can't find a senator to sign
the gentleman.
Objections.
Gentleman will suspend.
Won't sign objections.
The gentleman will suspend. The chair thanks the gentleman from Illinois, but hey, on the basis previously stated, the objection is not in order.
Now, imagine if Gore showed up in like 2002 with new, perfect proof that he should have won, and then he demands to be installed as president. Also, he claimed to retroactively be president this whole time too. That would be just ridiculous, especially since in reality we did actually discover proof that Gore probably should have won. The nature of the American electoral system, and all electoral systems frankly, is that it is not simply the person who wins the election who becomes the leader. It's the person who is the winner of the election up until the day of ratification. The winner can switch back and forth between candidates as a result of legitimate recounts and audits, but it's the ratification that grants actual political power. Even if Trump had the election stolen from him, and he didn't, when Joe Biden put his hand on that Bible on January 20th, 2021, it no longer mattered. Democracy may be the ideal way to choose a political leader, but it's the inauguration ceremony, it's the oath of office. These things actually imbue the leader with sovereign power, with the authority to rule, not the vote. That doesn't mean the vote doesn't matter. Of course it does. But it does mean that, at some point, recounts and audits don't matter anymore, even if they would yield legitimate results. And in Trump's case, they simply didn't. There's one final objection here at the very bottom. Some Trump supporters have been forthright, and have directly said they don't actually care if Trump tried to steal the election in 2020. They believe Biden's presidency has been a disaster, and that all things being equal, they'd rather live under the perceived prosperity of Trump, even if he does actually become a dictator. Well, okay, then own that position. Stop doing this weird pretzel game where you try to pretend that Trump isn't exactly what all the evidence lays him out as, that he didn't try to steal an election when he clearly did, while simultaneously just memeing that you want the God Emperor on the golden throne. You think life was just better under Trump, and you're okay if American democracy is eroded as a part of that trade-off. So own it. At least then we can have an actual honest conversation about the facts, and not play this cope shell game like we have been for the past 4 years. And since we are at the end of the video, it is about time for me to drop my own view of things. So here it is. Trump tried to steal the 2020 election. After everything we've gone over today, that is the only reasonable conclusion someone can come to. And this isn't Trump derangement syndrome. I'm not sewing out about 2 scoops of ice cream, or locker room talk, or any of that other cringe shit that the media lost their minds over during Trump's presidency. This is a simple, straightforward analysis of the facts. When most people think, oh my god, Trump tried to overthrow the election, January 6th was a coup d'etat, they're thinking about the riot in the Capitol building. I'll address that topic in a future video. But for now, no. When I say that Trump tried to overturn the 2020 election, I'm not talking about a crowd of hillbillies who broke into the Capitol to order a pizza from Nancy Pelosi's phone and sniff AOC's shoes. The riot's contribution to the day's events was basically just extra pressure on Mike Pence from the outside, in alignment with Trump's internal pressure to get him to reject the alternate electors. But the core of Trump's scheme unfolded inside the government, not outside the Capitol building. It's been hours now, so I don't blame you if you've forgotten, but think all the way back to the beginning. Judge Joseph Story in his seminal 1833 book, Commentaries on the Constitution, where he laid out how, due to vagaries in the Constitution, a corrupt presidential candidate might be able to overthrow an election with the help of a small group of corrupt congressmen, conspiring together to exploit a loophole. Well, we have the candidate, we have the claim with no legal basis, and we have the cabal of House reps, meeting in private on December 21st, after which they all began to do what Judge Story theorized they'd do. In that email chain between Jacob and Eastman, Jacob stated, "We were in the middle of an open, widely televised debate that was airing every single point that you gave to the members of Congress when the rioters breached the building and we had to suspend. We were giving you precisely the transparent, open debate that you suggested we weren't. It was up to you and the legal team to arm the House reps with a case at least sufficient enough to convince a Senate that our own party controls, and I'm not hearing it, especially because we evacuated." The House reps at the December 21st meeting, whether they truly believe the claims or not, were operating at the directions of John Eastman and Donald Trump, both of whom knew what they were saying was false, and that their plan was against the law, doing exactly what Judge Story said a corrupt presidential candidate would do if they wanted to steal an election. Trump tried to overthrow the 2020 election by using the power of his office in an attempt to extend that power in a way not compatible with the Constitution or legal precedent. He attempted to stretch the limits of legality and have Pence claim powers not afforded to him in order to reject legitimate electors, representing real votes from real people who had voted Biden instead of Trump, in an attempt to claim a second term he did not rightfully win. This is not a traditional coup. It's known as a self-coup or an auto-coup, where an otherwise legitimate leader uses or manufactures a crisis in order to justify rejecting normal law and procedure, to bypass courts and legislatures, and to unlawfully assume or extend emergency powers. To be honest, this form of coup has historically been more successful than traditional violent revolution, and many of history's most famous dictators across the political spectrum have cemented their power with self-coups. Like, for example, Julius Caesar, who declared himself Dictator Perpetuo in order to solve a political crisis that he had created by marching his legions across the river Rubicon in northern Italy. Or King Gustav III of Sweden, who, at 10 a.m. on August 19th of 1772, while Sweden's parliament was paralyzed due to a bitter division between the two main parties, gathered up all army officers loyal to him in the city square, rode directly into the palace on horseback, and had them all swear a new oath of allegiance to him personally. Sweden's political dysfunction meant that nobody could get their act together long enough to oppose him, and he established an absolute monarchy without any bloodshed. Or Napoleon. No, not Napoleon Bonaparte. His nephew, Napoleon III. He legitimately won the French presidential election in 1848. However, the Constitution at the time prevented him from seeking re-election in 1852. So, throughout his tenure, he filled key government positions with loyalists, and on December 2nd, 1851, he dissolved the National Assembly, drafted a new constitution, and declared himself emperor, a plan called Operation Rubicon, alluding to Caesar. Or Hitler. The Nazi Party won the election on March 6, 1933. And afterward, inspired by the political theory of Carl Schmitt, they passed the Enabling Act, granting the Chancellor the emergency power to pass laws without the consent of the Reichstag, and also allowed for those laws to violate Germany's constitution. Hitler used these new powers to establish a totalitarian state. Or Hua Guofeng in Communist China. After Chairman Mao's death, he used his power as premier to accuse his rivals of conspiring to overthrow the government, had them arrested on that charge in the middle of the night, and then walked into the Politburo the next morning, where he was elevated to the position of chairman. Or Maduro in Venezuela. He legitimately won the presidency in April of 2013, and by October of that year, the National Assembly passed an enabling law which allowed him to declare laws without the legislature, much like Hitler's. In 2015, Maduro's party massively expanded Venezuela's high court, filling the new seats with Maduro loyalists. And in March of 2017, the court declared itself to have total power over the National Assembly, including its authority to pass laws. In each of these cases, with the partial exception of Caesar, it wasn't a revolution or a civil war that led to power illegitimately changing hands. The only thing that was required was the tyrant's will to declare themselves as having power whether they had it or not, leaving the ball in their opponent's court to react to the move, just as Trump tried to do. It turns out illegally seizing power is easier after you've already legitimately earned it. It's my opinion that if Trump had any respect for American constitutionalism, he would not be trying to violate the spirit behind that same constitution so blatantly. Trump is uniquely unfit to lead the United States as a result of his actions related to the Eastman scheme. His actions on January 6th constituted a real attempt to overthrow the American government. Again, it's not like the Capitol rioters were these rebels looking to install a new regime directly by force. That's not what went down, and frankly, the progressives who soy out about it constantly just don't know what they're talking about. However, appealing to the failure of the rioters is just deflection on behalf of the Trump loyalists. Trump's coup attempt didn't unfold outside the Capitol building in an angry mob. It unfolded in private phone calls and meetings in the White House, where he attempted to pressure Mike Pence to accept a false set of electors, forged by low-level Republican Party members in 7 states, with the intention of using them to bypass the vote and install Trump as president. It was a coup with a pen rather than a sword. Trump is a traitor to America, and the peaceful transfer of power continues solely due to the patriotic actions of Mike Pence. He stood by the letter of the law and the spirit of the Constitution in his consistent resistance to Trump's pressure. And it's his integrity, his strict adherence to the quintessentially American values of constitutionalism, democracy, freedom, and rule of law that has led him to basically lose his career. Who would have thought that Shock Me Daddy Pence, of all people, would become a hero of the Republic? What a wild ride the Trump era has been.